Good afternoon, everyone. The Honorable Principal Judge, the Honorable Attorney General, the Honorable Judges of the various High Court circuits, the Chief Registrar, Senior Counsel present in the room, the President, Uganda Law Society, heads of Uganda Law Society committees and clusters, the membership of the Uganda Law Society physically present and online, the various members of the Uganda Law Society Students Association, the leadership in the room, all protocol observed. My name is Moses Okwalinga. I serve as the Chief Executive Officer at the Uganda Law Society, and I welcome you to today's engagement. I would like to begin by extending our gratitude to the Honorable Principal Judge for making this possible, as well as the Office of the Chief Registrar and the judges of the various circuits of the High Court for accepting to be with us here today. Apologies for the time we've lost, but I'm glad that all our stakeholders are now present in the room and we are ready to begin. We have an online audience currently online, and we hope to have a very engaging discussion. At this juncture, allow me to invite the Honorable Principal Judge to take a seat at the front, the Honorable Attorney General, the President of the Uganda Law Society, to lead our delegates to the front. Our moderator this afternoon will be none other than Senior Counsel Moses Adrico. Allow me also ask Her Worship the Chief Registrar. I think I've seen him. As we wait for the Chief Registrar to join us at the platform, allow me request all of you to stand up. And Simon from the Secretary to lead us in a word of prayer, and then we shall play the national anthems, the East African and the national anthem. Simon? Simon, please lead us in a word of prayer.
Lord Father, we thank you for the gift of life. We thank you for this gathering. We thank you for whoever is here. Lord, we thank you for this gathering, and we pray that whatever we're going to deliberate on today, to be grateful for the good of our nation. We pray to the Lord.
Amen. Could we remain standing for the national anthems and the East African anthem? Drake?
Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tuilinde, tuajibike, tuimarike. Umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you very much. If you could please take your seats. At this juncture, allow me to invite our host, the President of the Uganda Law Society, to make his remarks. President, you're welcome.
The Honorable Attorney General, the Honorable Principal Judge, the heads of divisions, my lords, the Registrar, Your Worship, the Chief Registrar, Your Worships, members of the bar, distinguished guests, members, ladies and gentlemen. I want first of all to take this opportunity to welcome all of you to our first annual bar bench engagement for the year. I hope that we will have another one perhaps after 6 months. First, allow me in a very special way to thank the Honorable Attorney General and the Honorable Principal Judge and the heads of divisions for their commitment in ensuring that they listen to the concerns of members. I must appreciate them for taking the time off. This engagement follows a specific meeting we had with the Honorable Principal Judge, at which we agreed to have a bar bench stakeholders forum with all the heads of the divisions. Let me also thank the membership. I know that we have, I think, over 100 members online for being able to attend this discussion. During that engagement, we agreed that it was necessary for us to share our concerns since we are the principal clients and users of the judiciary, and it was also important for the judiciary to share their concerns so that it's not just a one-way dialogue, it's a two-way dialogue. We also agreed that the matters we discussed today must be followed up so that we don't discuss the same issues every single time we meet. And therefore, this engagement has a specific action matrix that will be used for purposes of monitoring the implementation of the issues that we have raised. During that meeting, we also informed the principal judge that it was also important for us to have this on a semi-annual basis so that you don't just have one engagement a year and then wait after a year for the next engagement. So our hope is that we will have another engagement after 6 months. Lastly, I would like to encourage all the members to be candid. Please share your concerns when the time comes. And let's share these concerns so that we can together improve the delivery of administration of justice in this country. I know that most of the time, though we have provided for the agenda, most of the time is to listen to you. And therefore, with these few remarks, I want to take the opportunity to invite the Honorable Principal Judge to share his welcome remarks. Thank you.
The Honorable Attorney General, my lords, the heads of High Court divisions, Your Worship, the Chief Registrar, Your Worships present, the President, Uganda Law Society, members of the bar, and particularly to begin with the senior counsels, distinguished guests, ladies and gentlemen, greetings to you all. I welcome you all to this meeting, and I thank you for finding time amidst your busy schedules to attend this meeting, either physically or online. Your presence is a manifestation of your commitment to add building blocks on the mission of achieving a high-spirited and healthy coexistence between the bar and the bench, with the main goal of justice for all. As you may recall, we last had a meeting of this nature on April 19th, 2022, which to me is a little bit long. We need to have this on a semi-annual basis, as the President has stated. That meeting was, among others, intended to, one, streamline the relationship between the bar and the bench, to eliminate mutual mistrust, bring out the challenges the bar is facing in the pursuit of administration of justice, and find ways and means of revamping confidence in the administration of justice and the legal profession as a whole. This afternoon, we gather here again for the same reason. And as the President suggested, we don't need to come here and repeat the same words or things. We need to come here and have an action matrix. We say, last time this is what we raised. How far are we? Where are we? Why have we not reached where we are supposed to be? That is very critical. Otherwise, then we shall just come here and make speeches. We must have action points, which we must follow up. At the last meeting, both the bar and the bench made commitments to work towards rehabilitating the image of the legal profession. The bench, on one hand, to live up to the judicial oath by strictly adhering to the judicial code of conduct, and the bar, on the other hand, to pay allegiance to the duty owed to the court, clients, and the public in general. I commend the members of the bench and the bar alike for the steps so far taken in the right direction. Slowly but surely, we shall achieve the intended mutual results with continued transparency, accountability, and mutual trust. I believe that the tradition of continuous engagement through this and other forums without opting to wash our dirty linen in public spaces is testament to our mutual desire for an independent and honest bench and a strong and vibrant bar. Rendering justice is therefore our joint and cordial responsibility. Advocates are under a moral and legal obligation to be fair and cordial in their dealings with the court. This does not mean that the advocates have to surrender to the improper behavior of particular judicial officers. The advocates have the legal right to object to the improper behavior of a judicial officer, but their objection should be raised through proper forums, such as raising complaints with the higher authorities or considering revision, review, and appeal processes provided for in the law. That way, the sanctity of the courts will be maintained. In this regard, I commend the advocates for their behavior shift. And like in the past, I have not recently had many instances of insolent or insulting behavior by advocates against judicial officers. In the same breath, I applaud the bench for progressively ironing out judicial lapses that had reportedly become notorious in the past. This is commendable, and moving forward, let us all strive to do better. However, of course, I have received the matrix from the President of Uganda Law Society, which has some of the issues you raised, and I'm going to, well, not maybe now, but I'm glad that at least you're able to raise many of these issues, which I've received a package of them. And since I have a meeting with the heads of divisions and the circuits, we shall dissect these problems there, as highlighted. We are having a meeting this month, and this meeting is actually timely for our quarterly judges meetings, so that we iron out these problems as you highlighted them. However, despite the above improvements, there is an increasing concern of some advocates continually breaching the sub judice rule. I wish to bring your attention to Rule 20 of the Advocates' Professional Conduct Regulations, which states as follows. An advocate shall not make announcements or comments to newspapers or any other news media, including radio and television, concerning any pending, anticipated, current litigation in which he or she is or is not involved, whether in a professional or personal capacity. What I've seen these days, and is becoming a habit, that lawyers immediately after attending a hearing session, then they come for a press conference. And they start, talking about how they are dissatisfied, why they are unhappy. I mean, this is in your law. I thought that we should avoid. I know some of you, of course, try to pray to the gallery. Maybe it's a form of advertising, but I think we need to avoid this. Because these are matters which are still progressing. Now, when you start telling the public that, the judge was wrong here, the judge is, what do you want the public to decipher out of your comments? I think we should desist from that. You can, if you come out, you can say, well, the matters are progressing well, or we shall comment after the case has been concluded. There are some advocates who have made it a habit to prosecute all their cases in the media. Please be advised that that is wrong and a breach of the law. The sub judice rule serves 4 purposes. The first is to avoid prejudicing the fair trial of an issue. This focuses on the publications that might influence judicial officers and the public at large. The second rationale is to preserve the impartiality of the judicial system. This involves keeping away publications that would exert undue influence which might affect its operations, or at least might appear to do so. The third rationale is to prevent the compromise of the system of evidence which would occur through public availability or inadmissible evidence. Finally, the rule seeks generally to uphold the public interest in the new administration of justice. I know where, especially in the criminal justice system, this is where it is common. That's why I've seen, advocates making a lot of public pronouncements after either, a bail application hearing, or, they always come out, these fellows in the media are always following them, and then they have an opportunity to show the whole world that they're actually representing a serious client. The chief concern regarding media coverage of court proceedings is the danger of trial by media, where biased or ill-informed coverage may influence the outcome of court proceedings. This concern is particularly heightened in criminal cases where the presumption of innocence is a key component. We should therefore all take serious the issues of observance of the sub judice rule. Allow me, for emphasis, make a recollection of the fundamental role of the bar and the bench in strengthening relations for the future administration of justice. Every advocate is responsible for observance of the rules of professional conduct. Firstly, counsel must appreciate that his or her duty is not only to his client, but extends to the court and society at large, whose overriding interest is in ensuring that justice is done to all in all cases. In this regard, justice should be viewed as a three-way traffic. 1, to the court, an advocate should be respectful and courteous towards the presiding judicial officer. The reverse is also true. Let all remember that respect is earned, not demanded. I think courtesy. I remember when maybe these days, I don't know. I think I raised it with the president. I don't know whether it is the training, but when we were beginning as advocates with our seniors like John Mary Mujisha, who had taught us at LDC, they had really taught us how, decorum. If a senior counsel appears, even if your case has, commenced, we had the audacity of saying, "Oh, my Lord, or your worship, senior counsel has entered. May you begin with with the senior counsel. Of course, I'm assuming that cases, maybe for some reason, two cases are consolidated together. Otherwise, ideally, they should be staggered so that the two advocates don't appear at the same time. However, that courtesy, respect the judge or judicial officer or magistrate. You don't have to say, well, maybe I know you don't, as long as someone occupies a certain position, is a grade 1 magistrate, and you have decided to appear before that grade 1 magistrate, don't remind him that, do you know, I told you at RODC. I don't think John Mary has ever said that to any of us. No, because that's courtesy. He's a G1, yes. Perhaps you taught him at university. I remember one time I appeared in the Supreme Court with the Omnyokor. Is Omnyokor here? Yeah, okay. He's the one who had appeared, of course. So, and anyway, let me spare you the story. But he had taught us, but he was, according me that courtesy, that respect, my land friend here, but he had taught us at RODC. Advocates have a duty to assist the judges in the trial of cases to arrive at a proper decision by presenting the relevant evidence and the law in a proper manner without concealment of material that would otherwise be helpful to the court. Even when you have a case which you think is against your client, you should submit it in, but then distinguish it. That is the role of the advocate. Advocates are called upon not to indulge in conduct that is intentionally calculated to delay a trial. Some advocates file endless applications with the motive of delaying the determination of the actual dispute. In the end, this creates more backlog with its attendant effects. I think this is becoming a problem, and I think my lords, the heads know this, where an advocate files application after application to ensure that the trial does not take place. That is very dangerous. The court expects advocates to stick to the timeline set by the law or issued by court. The advocates must maintain court decorum. These days, it is common actually to see advocates coming in open courts with no robes. And then they ask you, oh my lord, I pray that you see me. I actually thought this matter was going to proceed in chambers. The advocates should not be seen to connive in blatant contempt of court orders. To the public, the advocate is expected to act with integrity. As I mentioned in our last meeting, the major concerns from the public against some advocates have remained as, number one, corruption. You advocates, sometimes you tell your clients, by the way, my fees is 5 million, but the judge also needs 5. So give me 10. That is quite common. And where I sit, I always get these complaints from the public. Someone comes complaining that actually your judge received money from me. Then I ask, so how do you know that he received it? Then he says, my lawyer told me that 10 million was for the judge, and I paid it to him. Then sometimes I tell them, go and come with your lawyer. The lawyer never shows up, of course. You can imagine asking for a bribe for a judge which you are not going to give, which the judge is not going to accept. But you are telling your client the same story. Very dangerous. You are affecting the credibility of the judge who is innocent, but at the same time, destroying the entire profession. 2, withholding of funds received on behalf of the clients. This is I have received so many complaints of this nature. They think that I can punish you as advocates. But every time I receive these complaints, he received 500 million and he now hides from me. He no longer receives my calls. Failure to account for the clients for the money paid. I think this is the same really. failure to render professional services, inadequate representation in courts, and lawyers' failure to appear in court to execute instructions after being paid. You can imagine these clients believe that you are very serious human beings, and indeed you are. But they don't know that some of you are actually not that. You are very unserious. While a sizable number of you are serious, but there are those who are very unserious. You receive money and you start telling the client, go to the judge and adjourn. Today I'm not there. The next hearing, today, go tell the judge that I'm sick. Some of you will even forget and say I'm dead. So you find the client lying on your behalf. Then charging exorbitant fees which deprive the poor and the marginalized of access to justice. We have the advocates' remuneration and taxation of cost rules which clearly spell out what you are supposed to charge. So let's not, really overburden these clients with some of you charge, and then you have received complaints where some clients say, he asked me for 2 plots in addition to the money I gave him, a lot of things. Then, lastly, conniving with errant bailiffs for due process in execution. In fact, I have seen complaints which have come to me where advocates tell their clients to pay certain amounts of money to bailiffs which are not taxed, and far much above what the bailiff should be paid. Then to your colleagues as advocates, what duty do you owe them? Honor legitimate promises made to opposite counsel, even though not reduced into writing or enforceable under the rules of court. Counsel tells you, counsel, I will not be around because of the following. I pray that maybe you inform the judge for etc. When you reach there, you say, actually, counsel for the defendant is not here. He has not given reasons why he's not here. I pray for. Yeah, you know that. So he has already told you why he will not be there. Maybe there is a very big commitment, but that's something which is not written. Now, or you agree, let's settle the matter this way, and then you go against that, even if it is not in writing. Then you are supposed to act courteously and not indulge in bitter exchanges in open court. There is one time when I was circuit judge, when I chased 2 advocates who almost fought in my court. Fortunately, I looked for the court order. The court order had gone out. I only chased them away, but you can imagine attempting almost to fight in front of the judge. What type of professional training would that be? On the part of the bench, we continue to strive to ensure that judgments and rulings are delivered on time. I don't want to, because this is what I strive to ensure as an individual. And I hope my colleagues, you are striving to ensure that. Delay in adjudication of cases and long adjournments are avoided. Processing of records of appeal are expedited. And judicial discretion is exercised judiciously. That's what we strive to ensure. As to whether we live to that expectation, I think I've seen the matrix. We seem not to be doing it. In order to deal with some of the challenges we still face at the judiciary, we are in the course of implementing the judiciary's transformation agenda through, 1, recruitment of more judicial officers. We have done that at the magisterial level, but I think even at the higher level, we are going to achieve that. Operationalization of more high court circuits and magisterial areas, decentralization of courts of appeal to the regional level. This is work in progress. Decentralization of inspectorate of courts. We think when we decentralize the inspectorate of courts, these complaints you have of judicial officers not being at the session will reduce. Organizing trainings for both advocates and judicial officers in new areas of the law. And I think this has been ongoing. Improving stakeholder engagements, ensuring certainty of hearing dates. I've always told my colleagues that every time I have an opportunity that the advocates must have certainty in your court. If they cannot have certainty, then you are doing them injustice. Instilling excellent customer care best practices in all our staff. I know we still have a lot of challenges, especially at the administrative level of our staff. That customer care is still lacking. Maintaining organized archives and exhibit stores for easy retrieval of files. We've done this countrywide. Now, if you go to a court and you find that you cannot get a file within 5 minutes, you know that the people in the court are telling you lies. We have organized archives in all courts in this country by year of registration of the case and by number. So that if you go to a court and you want a file, you should get it in 1 minute. Not the earlier times when they would say, the clerk would tell you, cancel. You know, the files are in a disorganized manner. Maybe I will come on Saturday to look for it. But you know, on Saturday, maybe you facilitate me to come on Saturday. We have done always that. If you go to a place and you find a file cannot be retrieved in 2 minutes, then you can give me a call. Then zero tolerance to corruption. We have strived to fight this. Where it occurs, we have cracked the whip. And I think if maybe we should start publishing the interdictions. Fortunately, the disciplinary committee is headed by one of you. So I think maybe she should be able to give you statistics. Any judicial officer who is caught in any corruption, endeavor, we interdict and then send for disciplinary. Rolling out innovations such as small claims procedure, electronic court case management system, pre-bargaining, daily hearing of criminal cases, which has commenced in the communal division, but we think we shall roll it out. And we are going to strive, especially in the next financial year, to make funds available so that even in other courts, we can have daily hearing of criminal cases. I think today is for interaction. Let me not say a lot and then eat up into your time of raising issues which should help us to solve a number of issues. So this meeting has all heads of divisions. Maybe in the future we shall also involve heads of circuits. In the next financial year, we hope that we shall have an engagement where we have all circuit judges and judges in the divisions, as well as maybe a selected team like the way it is here. So that, and be candid. If you know that the problem is here, point it out. That's why we are here. With all these few or many remarks, I thank you all for listening to me. I wish us all fruitful deliberations. Thank you so much. Sorry, blame the MC. He did not guide me well on what I should do next. It's my singular honor to invite the Attorney General to come and make his remarks.
Thank you very much, Honorable Principal Judge. I don't know why he's even invited me to make the remarks, because I think he looked into my documents and said almost everything I had to say. But the Honorable, the Principal Judge, my lords, the heads of divisions of the High Court, my lords, judges of the High Courts present, Your Worship, the Chief Registrar, the registrars present, the President, Uganda Law Society, Senior Counsel present, State Attorneys present, advocates in your various capacities, invited guests, ladies and gentlemen, both present and online. I would like to first of all start by thanking the ULS and the High Court for organizing and inviting us to this meeting. I don't think we can overemphasize the importance of such meetings, but it is in this kind of forum that we exchange ideas and views and get feedback on where we've gone wrong, but I'm also hoping that we shall also emphasize where the courts have done well and where the advocates have done well, so we can pick up those good habits. But I would like to thank the judges more especially. I think now we are seeing, my lords, the judges more as human beings from us as the bar. When you interact with us at this level, we feel that we can actually share with you our experiences, and we thank you for that humility. I think it will take us a great distance. The government of Uganda will continue to support the judiciary to ensure that we do provide justice and durable justice at that. Today, it is for the bar and the bench to talk, to have a candid conversation. While we were preparing for this, I did pick out a few issues which I thought, as the head of the bar, I would raise here, which really are fundamental, and they may come back from different members in different ways. We have the delay of decisions, but we never quite discuss its effect. If you take 10 years to give a judgment and you award interest, someone has paid for that. So the courts need to think about that seriously. There is still the continued claims of corruption, which need to be strongly addressed, and the principal judge has pointed to some of those. But we are seeing a very, very dangerous practice of not following the principle of stare decisis. And the use of judicial discretion as an excuse to get away from decisions that you don't think you like. That is leading us to seeing a number of ingenious, or if I may say, dare to say disingenuous rulings or judgments. From a lawyer's perspective, and more so from the Attorney General's perspective, our work becomes extremely difficult. While we could avoid a matter coming to court by rendering advice, because of the 4 conflicting or 3 conflicting decisions, we go out for a game of chance, and that's costly. So we need to emphasize that the High Court must follow the decisions of the Court of Appeal, and the Court of Appeal must follow the decisions of the Supreme Court, so that we can have a semblance of order in our courts, and also for us to be able to render durable advice to a client. I need to be able to say to a client, the position of the law in Uganda is this. It was settled by the Supreme Court as such. It is always embarrassing when I am confronted with a decision of a High Court judge who departed with respect from the Supreme Court. That needs to stop. Then we have a problem of manifest delays in records of proceedings. When we delay records of proceedings, we delay, once a person decides to appeal, let's allow them the opportunity to leave the courts as quickly as possible, so that the High Court is a first instance court. It's a very busy court. So if the registrars are going to be kept running around chasing records of appeal, that's time lost on more valuable work. So that needs to be addressed. There is also the failure by court, which is really personal, to award instruction fees to the Attorney General. Again, I'm sure I've told you about stare decisis, but we need to review this. I am hoping for an opportunity to get back to the Supreme Court to discuss that. And it is a problem. We still have challenges with ECMIS, and I'm sure members will talk about that. But those are generally the general problems. The principal judge has spoken about the bits of absenteeism. We are seeing that changing a little bit. We are seeing a little bit of change in the courts on that, and we do appreciate that. Now, although we appreciate the challenges that we have highlighted above, we ought to also point out where the judiciary has improved from our perspective, because we know this is not a one-sided affair. The courts, we are seeing a lot more number of judgments being released. Unfortunately, from the bar, we are starting to know which judges issue judgments quickly. And that is going to create a problem of forum shopping, because everyone wants to get out of the courts quickly. We can tell you, no, this judge releases his judgments in 2 weeks, this one in 1 month, that one never. So you're going to find people avoiding the never, and that will create a problem. But we've seen a marked improvement in that area. We really appreciate the efforts in setting up the different circuits, especially for us from the Attorney General's chambers. We are seeing a lot of improvement in justice in the different circuits. There's been a marked improvement in the communication between the bar and the bench. We are seeing the use of technology, and we really appreciate that. ECMIS is getting better. We still have challenges, and that, like we say always, we have to continue working at it. But I think it's improving. We are seeing it being a lot better. But we've also seen a reduced number of proceedings ex parte, and we thank the court for that, especially from the Attorney General's chambers, where we are actually given an opportunity. At times, for many reasons, we are not there, but now we have seen that the courts are not proceeding, and it's helping us in reducing the number. But even inter-parties have picked it up from the lawyers in private practice, who have noted that it's very difficult to get the court to proceed ex parte, which is a good thing, because then we finish the matter and deal with it once and for all. And lastly, we have seen a continued engagement and much respect between the bench and the bar. And I think these improvements that are happening from the bench are going to encourage us at the bar to do better. That respect and mutual communication between the bar and the bench has improved greatly. As I close, and as we open the floor to open discussion, colleagues from the bar, this is not an opportunity to appeal your cases. These proceedings are not for appeal of your cases. What we are discussing here are the general common issues that affect the administration of justice, not where you're dissatisfied about the decision that was rendered against you. So let us discuss calmly, let us discuss honestly, and let us have wholesome discussion, but let us do it respectfully, both from the bar and the bench. I am advising anyone who comes up to speak not to use any name of a lawyer or a judge. We are discussing common problems. We are not discussing people here today. Because the person you may speak of as having been unfair to you may have been fair to me, in my view. And therefore, we shall end up into a discussion of the person and not the principle. So with those few remarks, I thank you all for listening to me, and I wish you the greatest deliberations, and let us hope we shall work for the betterment of our motherland, Uganda, for God and my country. I thank you.
At this juncture, thank you very much, the Honorable Attorney General. At this juncture, allow me to ask our President.
The Honorable Attorney General, my Lord, the Principal Judge, and judges of the divisions, I thought that when we invited the Attorney General, he would speak for us. Since he's now seeking for an opportunity to ensure that costs are awarded to the Attorney General, I'm going to request Senior Counsel Moses Adrico to come and share concerns as members of the bar. But my Lord, the Principal Judge, and the Honorable Attorney General, allow me just to recognize Senior Counsel present. Otherwise, I may never get the title. So let me ask Senior Counsel Ruth Sebatidera to stand up for recognition. She's also a representative of the Judicial Service Commission. You're welcome. Let me also recognize Senior Counsel John Mary Mugisha. Thank you for coming. my lord and judges, the people behind you and the members are chairpersons of our committees. So we have committees as Uganda Law Society, chairpersons, deputy chairpersons of committees and clusters. Those are the specially invited guests. So we also recognize them for their efforts and invite them to this special Bar Bench Forum. I will also recognize, I think, the East Africa Law Society treasurer. Since you're the only person from East Africa Law Society, I'll ask you to stand up for recognition. My lords, I'll now hand over. I'll just simply explain the simple process. We asked members to share their concerns and comments. They shared their concerns and comments online. So for those who shared, we have a matrix. But I'm sure that there are those online and those present who would like to share more concerns. Senior Counsel Moses Adrico, you're welcome.
Thank you, Mr. President. My Lord, the Honorable, the Principal Judge, the Honorable, the Attorney General of Uganda, my Lords, the heads of the divisions, my senior colleagues at the bar, state attorneys present, your worships, my colleagues, friends, and comrades. It's my singular honor this afternoon to moderate this session. And I thank you, Mr. President, for calling upon me to moderate this session. As, if you may allow me, my lords, as has already been said by the President, we have already received from our colleagues a number of emerging issues. Obviously, some of these issues have been discussed at previous Bar Bench forums, and I'm very pleased that the President today has said that they will now create a matrix in which we can start tracking resolution of some of the issues that our colleagues at the bar have raised. The Honorable, the Principal Judge, has made, in his remarks, pointed out the importance of ensuring there's harmony between the bar and the bench. Indeed, these sentiments were re-echoed by the Honorable, the Attorney General. And I think this afternoon we shall go a great way to ensuring that this harmony is not only maintained, but it's enhanced, and we are accountable. It's very important that we are accountable because we all serve justice. As the President remarked, I commend the Law Society for polling over 300 advocates. Over 300 advocates were polled, and the concerns that arose have been summarized in 26 principal concerns. My Lords, the Honorable Attorney General, if you may allow me, I would like to now list the 26 concerns for those present online. Perhaps some of you present here in the audience have the matrix before you, but you will permit me for those online, and perhaps we could also put, for those listening to us on Zoom, I'll ask whoever is operating Zoom to put up the matrix so that our colleagues can see that their concerns have been addressed perhaps in these 26 concerns. The first concern, my Lords, Honorable Attorney General, is few numbers of judicial officers. And this concern was raised principally for the commercial court, the family division, the industrial court, and the civil division. The second principal concern was inadequate staffing of courts. And this concern was principally raised at the family division and at the industrial court. The third concern was delays in fixing hearing dates or scheduling matters for hearings. And this concern was principally at the land division and at the industrial court. The fourth was case backlog, and I think this is a matter that has been discussed at length, and it's cross-cutting. The fifth was limited parking spaces, and this was principally at the commercial division and at the criminal division. The sixth concern was poor time management by judicial officers. And I am not going to single out any particular division, but it was to some extent a cross-cutting issue. The 7th was delay in delivering judgments or decisions. And unfortunately here I will single out principally the land division and the industrial court. The 8th was corruption. I think the Honorable Attorney General has spoken about this, and this is a cross-cutting issue across all our courts. The 9th issue was inadequate sitting space, and here the division that was mentioned is a criminal division. The 10th was the disappearance of files. And the Honorable Principal Judge, we thank you for telling us that these files ought not to be disappearing. But it seems that this is a malaise, principally at the family division. The 11th cross-cutting issue is long and multiple adjournments. And this is at the commercial division, the land division, both the commercial and land division. It seems the other divisions aren't as culpable. The 12th issue is ICMIS. Of course, we all know that with any new technology, there are teething issues, and perhaps we are so accustomed to using WhatsApp, we don't expect there to be any teething issues, but so maybe perhaps we are being a little harsh, but nonetheless, there was complaints about delays in registration of pleadings, admission of pleadings for most of the majority users, and also complaints that the judicial officers have not learned how to use XMIS. And this was cross-cutting across the commercial division, the land division, the family division, criminal division, and the civil division. I'm not sure whether ECMIS has been rolled out to the industrial court and to the anti-corruption division, because those two were not cited. So perhaps we shall seek guidance from the meeting. The 13th issue was absence of judges and stalled cases. There has been one judge that has been mentioned, and I think the name has been forwarded to Her Worship, the Honorable the Chief Registrar, and I'm not going to mention the name here, and so we shall leave it there. The 14th issue was the industrial court in Jinja is not operational, and I'm sure my lord from the industrial court will respond to that. The 15th issue was the internal procedures are not specified in the Succession Act, and I think this is for the Honorable the Attorney General. Perhaps he'll address this when he makes some supplementary statutory instruments. The 6th was about replacement of a particular registrar. Again, I'm not going to mention the name of the registrar, and that concern has been raised and forwarded to the Honorable the Chief Registrar. The next issue was there was a complaint about the new judges taking long to give hearing dates. I am not too sure. That's a little vague. I'm sure that is it's not really a huge concern. I'm sure that that also will be addressed in this meeting. The 19th issue was the unavailability and readiness of prosecutors to commence prosecution. And I think this is really with my colleagues, the state attorneys. I don't know whether there's anybody from the DPP present, but this is a concern. And if not present, perhaps the Honorable Attorney General can raise it with the Director of Public Prosecutions. The 20th concern was with the International Criminal Court Division, and the concern was that there was prolonged pre-trial detention. Indeed, there was a concern was raised that perhaps there should be some form of constitutional petition to delineate the length of time a suspect should remain in detention while proceedings, while there are proceedings at the International Criminal Court Division. The 21st cross-cutting issue was routine delays in fixing bail applications and delivery of rulings, and this was mainly with the Criminal Division. Then, of course, the perennial complaint about court clerks. I think this is a complaint that keeps coming up about court clerks being rude, non-responsive, corrupt, and so on. I think this is an issue that has been discussed in this forum on previous occasions. There are also concerns about individual judicial officers. Again, I am not going to mention those judicial officers against whom certain concerns have been made. This matters, if there's any water in them, has been forwarded to the Honorable, the Chief Registrar. And then, of course, the Honorable the Attorney General has already spoken about this. There are also there are complaints about delays in delivery of judgments and rulings. My colleagues online, these are some of the issues that a lot of you have raised. These are some of the issues that we will be discussing this afternoon. And hopefully, Mr. President, we shall have our matrix, and our rapporteur at the end of this session will outline the key issues that have been discussed, what actions we need to see taken, and as you have said, Mr. President, when we come to review these matters in 6 months' time, we can then measure our progress. At this juncture, I would now like to open up the floor for discussion. I think the Attorney General has laid down the rules of this session. We would like polite language. We would like respectful language to their lordships. We would like, as much as possible, not to cite names. And we would like, more importantly, solutions. We want solutions. We are not here to name call and so on. We are here to find solutions to improve delivery of justice in our country. That is our aim. So let us try and live to that aim. So if I may, I would like now to open up the floor for discussions, and perhaps I'll ask Senior Counsel John Mary to make some comments and or raise some concerns if necessary. Thank you.
Thank you, Mr. Past President and Senior Counsel. All protocol observed. I would like, first of all, to commend the judiciary and the bar for having organized today's event. I would like start by commending the judiciary for having established a vibrant public relations. For the first time, we have an effective person who tells the whole world what transpires in the judiciary in simple terms. Number two, I would like to commend the Office of the Attorney General for instilling professionalism in the Attorney General's chambers. Ever since the current holder came in, matters are handled professionally and efficiently as if it was a private chamber. And I would like to commend the AG for taking personal interest in all cases and not relegating any case to the periphery. Every case is prosecuted professionally. So I think he commends, he deserves our compliments. I would like also to commend the judiciary for having recruited, and especially the new breed, who are very vibrant, our contemporaries, and some of them I had the privilege for having tutored them. I would like to commend their judgments, especially those ones who have just come in, and commend the others, because now we get instantaneous judgments, and even the LDC, we have the instantaneous reporting by Mr. Mkivi. We have our own vibrant litigation WhatsApp where we do a lot of surgery. Whatever decision comes in, we brainstorm on it. And you keep in a, they call it commode, but you are benefiting. You are evaluating your prospective appeal, your chances. So you can see how those decisions, when they are put online and circulated, we in the private practice, we are able to criticize, we are able to plan accordingly. I would also like to commend the judiciary for HMIS. You can see the HMIS pin here. I'm one of those who advocate for HMIS, much as we are referred to as the ancestors. It has revolutionized the way justice is being delivered. Of course, like any new method, there are what we call the teething problems. But we, even the old generation, we are grappling and we are able to move with it. I would also like to commend the literacy. There is a particular trial, I will not name. The judicial officer in that magistrate's court began by carrying out some kind of literacy by informing the audience what the trial is about, what to expect, and when this trial commenced, people knew what to anticipate. So I think we should have a deliberate policy, if possible by all judicial officers, to take a few minutes whenever you get opportunity to sensitize members or the court users of the rudimentary methods of what to expect given any trial as a preamble. And then you can now descend into the nitty-gritties. So that criminal trial was very vibrant. It was on TV. The whole public was able to follow what was going on, other than, engaging in a lot of theories and hypotheses. We have a particular concern regarding some judicial officers who do not avail their decisions. There are some whose decisions have never come across continually. Why is it that some are very active and some do not avail their decisions? I think there should be a deliberate effort by the administration to ensure that whatever decision is delivered is availed. You can have some administrative mechanism. You recruit an officer who will knock on each judicial officer's chamber. And even if it is in raw form, you undertake to avail it to we who are in the practicing world and the general public at large. Then, of course, we have that problem of conflicting rulings and judgments and decisions by inquiry. Why don't you at least acknowledge that there is a judicial precedent somewhere? I'm not bound by it. But at least the one who is reading your judgment knows that you were alive to that decision. The doctrine of stare decisis and precedent has been relegated as if it never existed. I think one of the presenters had stated so. These are time-tested doctrines. You cannot simply shy away from them. So if you are disagreeing, tell us. I know there is a decision where you have failed to comply with someone's directions, but I decide, or I beg to depart, or not. But of course, there are those time-tested decisions of the superior courts, which you are bound by the doctrine of precedence. But there is a lot of innovativeness these days under the cover of judicial discretion, whereby and for us in private practice, we are left in uncertainty. There must be certainty and predictability as far as legal practice is concerned. Sadly, there are some decisions which have not been delivered. I have a case in point, some judgments from Mbarara. I think they were handed down by the late Justice Manira Guha. This is the third time I'm raising this issue in a forum of this nature. I was told that they were bound together and stored somewhere in an archive in industrial area. Up to date, we have not received judgments. And I'm personally concerned because I have those pending judgments. I don't know how many years now. Over 10. Yeah, so this, the administration should look into it and ensure that those decisions are delivered, or you give some remedy to the parties. Issues of discipline. Of course, for me, I have the unfortunate, I think I'm one of those who have trained almost, I think, about 3/4 of the lawyers in the country. So whenever I appear, especially with the young generation, those who do not know me, one had the audacity of saying, my lord, I don't know that gentleman. He can introduce, how can you be so callous? Call the whole of myself, that gentleman? Weren't you taught? Eh? No. You have the courtesy of introducing, and you should have availed your name to senior counsel, so that it's the senior counsel to introduce you. You don't simply say, that gentleman, I don't know who he is. He can introduce himself. No. We cannot degenerate that level. Let us maintain the decorum. And of course, to err is human. At times, my lords, you are not having your robes, and some of you jump into open court without informing us. And we have the unfortunate circumstance to pray to be seen. So please, we pray that you should take each case according to its given circumstances. As I'm concluding, I would also like to inquire, why haven't you invited the DPP to take, because it's a very important office. And by the way, I would also like to commend them in absentia. They have also made their office now very professional. And as far as we are concerned, this is what we should have in all departments, to be conducted professionally. So next time, please, we invite the DPP to be amidst us here so that we can brainstorm on these issues. Otherwise, I would like to commend the judiciary and the bar for having availed us this opportunity. For the first time, I think here we have some kind of immunity. Tomorrow you'll not go after me and say, you guy. Eh? But I'm sure I've never told anybody that I taught you, or this is the civil procedure, or what. No. I think I've been as courteous as can be, and I pledge I will continue to be courteous. Thank you very much for listening to me. I rest my case. Thank you.
Thank you very much, John Mary, Senior Counsel, for your sagacious and humorous remarks. I recognize the Commissioner of Civil Litigation. I also see him sitting there with Mr. Richard Adrole. I do not know whether the Commissioner of Civil Litigation has some remarks and or comments. Please.
Thank you, Senior Counsel, but as you're aware, I come from a chamber that is headed by the Attorney General. Once he comes and says something, everything I said is binding on all of us. So I go by what the Honorable Attorney General has said. I thank you.
Thank you. Mr. Magdasman Kabega, would you like to make some remarks, please?
Thank you, Honorable Attorney General. Thank you, the Honorable Principal Judge, my lords, all my land, the worships, the registrars of the High Court, and all my land friends. Mine is a small one, and it is in respect to this meeting, the bar bench. The Law Society president came up with an idea that the Law Society should create committees or rather a committee, which will be liaising with the various divisions of the courts in respect to the concerns of counsel vis-a-vis the court. They made me the chairperson of that committee, and we had a first interaction of such a meeting with the commercial court in the month of late March. We had very good deliberations, and we thank the head of the commercial court and the judges of the commercial court also for having availed themselves and organizing that meeting, which was very fruitful, and some of the concerns which are now being raised by the lawyers are those which Mr. Madrico has talked about. Now, as a result of that interaction with the president of the Law Society, it was decided that we will have subcommittees which will be of about 5 individuals, which will then be directed to different divisions of the courts so that they interact with the judges of those courts, of the division. They get the concerns of the lawyers and the concerns of the judges of that division, and then, for example, before even come to this fora, we have kind of digested the issues which came up in those discussions. And my request, therefore, is that when these various committees are set up by the president of the Law Society, my lords, the heads of the various divisions, should give them time and facility to meet with them, discuss, put across all the issues which they have for the betterment of the dealings of both sides. Lastly, on the question of delay, I have one particular matter which I think would be of interest to this meeting. That matter, without divulging the details, is with the ICD division. Some 16 individuals were arrested in 2012 or thereabout. The office of the DPP and police took about 2 years to come up with evidence which they could present for pre-trial. The pre-trial took 2 years to complete. Then the judge who conducted the pre-trial in respect of this matter, which took police and DPP's office 4 years to put together, was done in a period of about 3 weeks. And then he gave a ruling. Now, from late 2014, the trial only took off in 2020. And when it started, it had to be adjourned because the office of the DPP wanted to put the exhibits together. So the trial started late 2020. The first witness gave evidence in 2020, and this evidence was completed at the end of 2021. In 2022, then of course with COVID, but immediately after COVID, this matter came up again within a period of 3-4 months. Another 5 witnesses testified, and that was the end. The judge said he was retiring, but since then, up to today, the one suspect who is still on trial is now 9 years on remand. And when we attempted to put in an application for bail, the judge told me, "You'd rather not try that because I can assure you it will not be granted." That is last year. So I would like the judiciary to take keen interest in this matter. Then lastly, also on the question of delays, is a matter we handled again in the Supreme Court, where we finalized all the submissions 2 years ago. Last week, we are given a notice which we thought that was a judgment notice. So when we appear in court, only to be told that they are going to reconstitute the panel to rehear the case. And again, there are some 2 people, 4.5 years in prison. But this is the Supreme Court. My Lord, the PJ, I think it would have been imperative for some of the judges of the Supreme Court and even the Court of Appeal to be invited into this forum. Thank you.
Thank you, Senior Counsel Magdasman Kabega. I think your recommendation for the invitation of my lords in the Supreme Court and the Court of Appeal have been heard, and I suppose that will be one of the matters that we'll be putting in our matrix for action. At this juncture, I'd like to, I know, by the way, that we have over 150 people online at the moment, and I know that they will want to be, I will be reading out their comments, but before I do so, I give you the floor. Please stand up. I know who you are, but please introduce yourself.
Thank you, Senior Counsel. Ladies and gentlemen, in your distinguished capacities, all protocols observed. My name is Counsel Anne Karunji of Karunji and Partners, Advocates and Solicitors. My concerns are only two burning concerns. And one of them is the fixing of matters by judges in a small space of time, within the same time frame. What do I mean? A judge will fix 10 matters on a Monday morning at 9 a.m. Really. 10 matters, which include hearings of applications, hearings of suits, and mentions of matters. As you all know, time is our stock in trade. Lawyers, we are not idle people. We are here to serve the nation. So you find you're rendered incapacitated, you're rendered redundant. You're seated in a courtroom in the commercial court waiting for the judge to call your file, which was fixed at 9, and your file is called at midday. And then you have another matter. For some of us who have small law firms, you have to run around, so you have another matter, maybe an adoption cause in the family division, before another judge. So really, it makes our work very complicated. So I thank you for this fora, and I pray that this matter will be looked into, Madam Chief Registrar, so that at least, you know, we are seen to serve well as you also serve us well. Thank you.
Thank you, Ms.
Then the second matter is, my call is for the continuous training of judges. The continuous training of judges on, you know, matters of civil procedure and practice. you find that you get a decision and you're left dumbfounded, with all due respect. You find issues like, when does a court order become stale? What time frame does it take for a court order? There is a time, without mentioning names, a judge was about to deliver a ruling. Then I asked him, my lord, have you had the opportunity to read the decision of Green Pastures by Justice Madrama that says that after 12 years, a court order becomes stale? He said, I wasn't aware. So my call is that we need refresher courses in the judiciary, that judges will be appraised on some of these matters, so that, you deliver your judgments with confidence and they are well thought out, thought through. Thank you, with all due respect. Not to say they are not, but, thank you.
Thank you, Ms. Karunji. As we digest what you have said, you'll allow me to inform the audience present this afternoon that we have over 720 people with us online. And at this moment, I'd like to read some of the comments. Perhaps they could be put on screen as well, from what we have received. I will start with Mr. Bruce Cherere, Senior Counsel, in which he says that some of the new practices are overburdening advocates with documents, like letters and the processes prior to hearing. One has to write letters requesting for dates instead of just presenting hearing notices for the clerk to fill in and serve in the parties. I think his concern is, how can we tweak ECMIS, perhaps to do some of this more clerical and more mundane work, rather than have it left to the advocate, especially for those advocates like Ms. Karunji, who are in smaller chambers and who perhaps do not have as much administrative support. We have a comment here from Mr. Robert Bogere, and he says that his concern is about decisions which are contradictory. And he says that it used to be the case that when you buy land and cheat government of its revenue by undervaluing the land, you are not a bona fide purchaser. I saw a contrary decision saying the defaulter simply tops up. So I think, again, perhaps maybe it goes to the issue of stare decisis. I think there are some Supreme Court decisions on that particular issue, which perhaps Mr. Bogere can read up. I recognize Mrs. Lydia Ocheng-Obo. I think she's present. I'm not sure whether she would like to make a comment and or perhaps contribute. She's always solution-oriented, so I'm sure she has some solutions to some of the issues that we're addressing this afternoon.
Thank you very much. I think I'll adopt the procedure before of all protocols observed. And I would like to make maybe one or two to three comments. One of them is about the delays in issuing practicing certificates. I think this year, a number of us suffered the fate of not being heard because our practicing certificates had not yet been delivered. And I think this is a matter that goes to the Uganda Law Society, with all due respect. It goes to the Uganda Law Council, and I think the person responsible for issuing these certificates at the judiciary. I don't know what solutions we have for this, but I think it's becoming a problem, partly because I think the Uganda Law Council cannot handle the multitude of law firms in terms of making sure that they do the inspections in time. So I think we need to review the process to see how best we can make it shorter so that the certificates are issued in time, so that the judges can hear us. I don't blame the judges because they expect us to be properly before them. So I think we need to do something about it, and the president of the Uganda Law Society, together with the those at the Uganda Law, the Law Council, should look into this matter. I'll talk about a very controversial subject as well, which is about the scarcity of judges, which I think has been alluded to by the previous speakers. And I've made some controversial statements on this one, and I beg to be excused if I don't please some of the members here. But I think I find that actually we are retiring judges very fast. And then no sooner have we retired them, and I think some of them can still work, and then we are saying, oh, we don't have enough judges. What can we do to actually continue using some of the energy that is still out there? I mean, is it correct? I'm 65 this year, and I'm not ashamed to say so. So if I was on the bench, I would have already retired, regardless of whether I'm still able to work or not. We need to address that issue. In other jurisdictions, judges are working until 75 and so on. So I stand here to say that we need to review that issue. And if there are some judicial officers who can still serve, the issue of 60 years should not apply. I know that the young lawyers are clamoring, if they don't retire, when shall we come to the bench? My friend, those of you who are young, is that you still come to where we are right now. One day you will be standing here talking like I'm talking. It's not about age, it's about the capacity to serve and the ability to serve. And I think even if we brought back the few that have just retired, for instance, last year, you will still have space to serve because there's still room for one staff on the bench. And not everybody is made out to go to the bench. And we are very many, we are about 5,000 as we speak now, plus. The last one is really on the issue of stare decisis. And I'm going to speak not from what other people have said, but from the perspective of us, the lawyers. I read sometimes submissions that we write as lawyers, and have we lost the art of distinguishing cases? I think we should have the responsibility to help the judiciary. When you quote a case, you should distinguish it. It shouldn't be just a matter of, getting a case and throwing it in there. Are you quoting case if it is not relevant? But even if it is, you should be able to distinguish it. Then maybe it will help the judicial officers when they are looking at your submissions to render a much more definitive judgment, and also a judgment that is well reasoned in all the principles that we know that are applicable to rendering judgments. I think I'll leave it at that for now. And thank you very much, Past President Amos Adrico, for allowing me to make my remarks. I thank you.
Thank you very much, Senior Counsel Lydia Ochieng-Obo. There are some comments we have received online. We have received a comment from Counsel Richard Latigo, and his concern relates to practice directions issued by our registrars. Perhaps their worships present will also be able to comment about this, perhaps the manner in which they go about issuing practice directions. There's some concern. There needs to be a streamlining of that particular process. There's also a concern, actually quite a widespread concern, my lords, about when court is not able to sit because of some prior commitment, for example, workshops, seminars, and so on, that there ought to be prior communication to the advocates. This is an issue that has come up, and I think perhaps their worships can communicate this maybe on the Friday before the Monday when we are going to appear in courts, so that the lawyers then are aware that the Honorable the judges are not going to be present. These are some of the, I see a hand there. Counsel, you'll introduce yourself for their lordships. I know who you are, but for their lordships, please.
Thank you, Senior Counsel Adrico. My name is Patrick Turinawe from ENS Africa Advocates. The Attorney General, Principal Judge, Your Lordships, President, Senior Counsel, and fellow colleagues. My first comment is in respect of, with the trend of online judgments or online platforms, we have, there's a litany of judgments that are provided on WhatsApp groups. And in many scenarios, even the judgment notices might be provided on WhatsApp groups. You are not sure whether counsel involved in the matters are on those groups. And the effect is that you have scenarios where clients or counsel get to know about the judgments either in the newspapers or from other forums, and it creates that discrepancy where the parties need to know, to have the knowledge that a judgment has been delivered. We hope that that can be rectified. And the other issue is possibly to create a uniformity in how judgments appear. It might be a matter of form, but with the increasing numbers of judges, everyone comes with their own style. Everyone comes, whether it is the font, whether it is the, some are footnoted, others are not. I'll give an example that even we can take a note from other jurisdictions, our neighbors in Kenya or South Africa or the UK. You can see a judgment and know that this judgment is from this jurisdiction. And because they are uploaded online, you are not there, some of them are not signed. You cannot tell whether this is an actual judgment of the High Court or an appellate court in the country. In one unfortunate incident where this has been, you can see the effect is that a judge quoted a judgment from another jurisdiction, but that judgment was actually out of a moot court competition. And that is quoted in a judgment of a high court. How unfortunate that is. But I think such problems are created by just even the form of a judgment. And if we could have that kind of uniformity, I think it would create some orderliness in how the judgments are presented. And now even with the lower judicial officers, the magistrates, the registrars, everyone is doing their own thing. I think a uniformity will create some sense of order. Someone has mentioned about the absence of judicial officers, especially up country. You travel 2 days, put off a matter for 2 days, and then they tell you the judicial officer is not present. The resources, financially, time, it hurts all parties. Last week I had to engage, to directly look for a number of a magistrate up country and call them to get the assurance that they will be present before a resource is sent to their court, because we had missed court attendance on 2 occasions. The counsel are all there, present, ready to proceed, but the judicial officer is not present. And lastly is the procedures that come up in administrative procedures that come out in different divisions of the court. I think of late, the most common has been the family division, where you go to court, there is a notice on the notice board. Going forward, this is what should be done. It was issued 2 months ago. No one has an idea until you reach the court, and you are sent out of court because of that. If there is a circular that can be created for that, it will help administratively, but they are also unregulated. You wake up one day, something is new, it is not provided for anywhere. It may be administrative, but it should have legal basis. Thank you.
Thank you very much, Counsel. At this juncture, there's a gentleman, Mr. Mukibi, online. If we can air what his comments are, I hope that we have sufficient volume so that we can all hear. Thank you.
Thank you, Senior Counsel. Can I be heard? Yes, Senior Counsel, can I be heard so that I proceed?
Loud and clear. Please go ahead, Mr. Mukibi. We are a little short of time.
Thank you. One relates to the issue of delayed judgments. I think one of the strategies we need to devise is to take out the practice of fixing judgments and rulings on notice. This is a very, very wicked practice which delays delivery of judgments. The judge or magistrate tells you judgment will be noticed. You wait and wait, no communication. If you keep mentioning at least, say, come back after 2 weeks, come back after 3 weeks, you will feel the pressure. If these people overappear before you and you are not delivering judgment, you feel the pressure. But once you say judgment on notice, surprisingly, even in intellectual applications like a temporary injunction, somebody tells you ruling on notice on a temporary injunction. It's urgent already. That's we need really to do away with the practice of fixing rulings and judgments on notice. That will save the situation. Secondly, is the issue of administrative notices. Can we have some kind of assistance in High Court? Plus circuits. You go to Mukono, requirements for petition of letters of administration are different from those of family division, from those of Luwero. Now we have resorted to a practice of first calling the court. What do you need at your place before I make the petition? They give you a list of items, several of them. Now you do them. When you go to another court, they are different. Can we have consistent? This is all High Court, wherever it is. We appreciate some of the concerns of dealing with the fraud and what have you, but still we can harmonize such that we know if I'm petitioning to this court, these are the requirements. So that the requirements for Mukono are not different from those of Luwero, not different from those of Masaka. It really doesn't make a lot of, it is unpredictable what court needs. And some of these administrative instructions which keep coming every week, we don't know where has the Rules Committee gone. Somebody raised it to the Honorable Attorney General. We have the Succession Amendment Act has brought in so many things which are lacking regulations, and every court is trying to struggle to fix how to do it. Can we harmonize and we have consistency in what we are doing? Thank you, Senior Counsel.
Thank you very much, Mr. Mukibi, for your comments. They have been duly noted. I see a hand there. Is that? I'm sorry, I can't see. Perhaps I need eyeglasses. Yes. Please introduce yourself.
Thank you very much. I will. My name is Maxim Tabingwa. I'm an advocate of the High Court. I have the first one is the controversial one. Very many people never want to talk about it, and it is called corruption. People have said that corruption and adultery are rated. You know why? Because their evidence is hard to get. So there is a relationship between adultery and corruption because it is very hard to get evidence. But in my opinion, the evidence of corruption is not hard to get. Because you see, all of us are lawyers. We studied from the same LDC. What I'm talking about is that, you see, like in a judgment or in any case, there are three parts. We have facts of the matter, facts of the case. We have evidence. Then we have the law. So, if you mix the three things, then you are supposed, it is pointing somewhere. But you find that somebody, instead of pointing to the east, if you add all those ones, for him or her is pointing to the west. So it presupposes that there are two things. Either that person has been compromised, is very corrupt, or is very incompetent. So we have two problems. We have the problem of corruption, and we have a problem of incompetence, and they are rated. So corruption, at least in the High Court now, has reduced very tremendously. I commend the judges. The judges we have are very good now. Some corrupt judges, you know them. You advocates, you know them. Some have retired. Some have died. May their souls rest in peace. But we still have us in the High Court. But very, very few. I not name them, but I know them. So, why can't the Judicial Service Commission establish like a committee to review all the judgments of the judges and the magistrates? You see, people are suffering, especially in the lower bench, the magistrates' courts, up-country courts. The citizens are suffering. There is a lot of corruption there. You people, you are here in Kampala, you stay here. You don't know what is happening there. People are suffering. They are very poor. They don't have the capacity to complain. They don't know where the office of the chief registrar is, but they are there suffering. So, how do you help those people? Or also, the office of the chief registrar maybe can establish like a desk to review those decisions and judgments of the lower bench. Monthly, weekly, you will see evidence of corruption there. It is there. You just need to see the facts of the case, the evidence, and the decision. And you see that this person was compromised. And you are seeing it there. Oh, he is very incompetent. It is not hard. It is very simple. So the office of the chief registrar, the office, Ruth, I think that's why you should look to that one. The citizens are suffering, especially with the lower bench. Then secondly, it has already been said that the jurisdiction of the magistrates' courts, that it should be enhanced. But they have the power which they are not exercising. Recently, I was filing a divorce matter in Mukono. When it was filed, the chief magistrate said, but you see here there is matrimonial property which is above 50 million. So already she's attaching value to a divorce proceeding, a divorce matter, which is very wrong. Section 3 of the Divorce Act is very clear. Where all parties are Africans, a grade 1 magistrate can handle the matter. So when you take the matter to the court, magistrate's court, they say no, we don't have any power to handle the case. So you find we are filing all the to the High Court, and that brings a backlog unnecessarily. If it was possible, the register of the region would review all those files and send them back to the magistrate's courts, and then the judges would have time to handle very important matters, or maybe the divorce matters could come on appeal. Why do you have a small divorce matter before the family division of the High Court? Very small, instead of being handled by a G1. And then you hear, we are correct, backlog. That one shouldn't happen. Maybe they should enhance jurisdiction of the magistrate in respect of maybe land matters. There, of course, you know where our country has gone. 50 million is very small money. How much, I mean, where can you get land of 50? It is not there almost. So it means magistrates courts now no longer have jurisdiction to handle land matters. Then ECMIS. My senior land colleague, Mr. John Mary Mugisha, he was commending ECMIS. But I think he has not met its dangers. To me, where we are still, I think ECMIS has done more than good. Currently, as we stand now, the intentions are good, but I think it was hurried. They should have given it time and more resources, or maybe it would have been started in phases. But the way it was introduced to us, it is doing more harm than good. Things are not moving, I'm telling you. You advocates, you know. But when we, of recent, we attended some seminar with Bar Bench, they said, don't talk about ECMIS. It has come to stay. Talk about others, but don't talk about it. Okay, I'll stop there. About ECMIS. Then, also, I want to talk about the preparation of judges. Also, it brings a backlog. Many times we have gone to court, but you find the judge is not ready. Some judges don't read the files. You see, our work is very hard. You cannot go far unless you have read and understood the file. You cannot go far. Some judges are using personal assistants, even to write the judgments. And the quality of the judgment sometimes is not good. Some person confided in me at the High Court that, you see, this judge is using the personal assistants to write the judgments, and the quality of the judgment was not good at all, and you could see it. So it is better, instead of handling 10 cases, handle 2, but handle them competently. Because you see, a decision of the judge of the High Court, it binds all other courts. It binds us. So there should be some jurisprudence to help the whole country. Don't rush to finish the cases, but set jurisprudence. Give us guidance.
Mr. Mutabinga.
And when we go to court, a judge should be above counsel. When I appear as a counsel, I expect the judge to find or her more knowledgeable than me, so that I can be. This happens with the young judges. You find they have not internalized the CPR and the other roles, and then sometimes also it brings delays and the backlog. So I stop there, sir. Thank you very much.
Thank you very much, Mr. Mutabingwa, because we must allow my lords and our worships to be able to respond. We have had over 1.5 hours to raise our concerns, and at this juncture, I think this would be an opportune time to allow the honorable judges present and the worships present to respond to some of the concerns. I'm glad that at least we recognized some of the achievements that the bench has made under the leadership of the Honorable the Principal Judge. There have been a number of achievements, a number of improvements, certainly, to the manner in which that justice is dispensed. And my lords, we are grateful, but we always have to ask for more. We always expect better, but that does not mean we do not appreciate the efforts and the work, the very strenuous and difficult and very lonely work that you undertake on a daily basis. So at this point, may I ask His Worship Amos Kwizera to come, or perhaps stand up, make some remarks. There were some issues that were addressed to their worships, and thereafter I'll ask the different heads of divisions perhaps to make an address or to make some comments or some response to some of the issues that have been raised. Your Worship Amos Kwizera, please. Thank you.
Thank you, Senior Counsel. I will adopt protocol as earlier stated. I was not ready to make any comment. I was waiting to hear from my seniors. But I will make one. The Inspectorate of Courts, which I am in charge of as the registrar, as stated by the Honorable the PJ, the institution is targeting to strengthen it and even to put regional offices. We have gone away from the general inspections we have been making, but rather now we are looking at the quality of the of the services our judicial officers are offering. So we are more, I had one of our colleagues saying we need to assess the credibility of the decisions, and that's where we are headed. I was in the field the last 2 days, and I've corrected judgments from judicial officers. So at the Inspectorate, we are going to start assessing these decisions. Like Council Mutavingwa has said, when we detect a substandard decision, there may be questions to answer or to ask. Either it is a competence issue or it is a compromise issue. So some of these judicial officers at the lower bench will be tasked to tell us whether they need more training or they smuggled their law degrees. The rest, senior counsel, I leave it to my seniors. Thank you.
Thank you very much. For my colleagues online, I think we now have 750 members online. Those of you online, I'm going to introduce the honorable judges who are present today here. First of all, I recognize and introduce Honorable Justice Lawrence Gidudu, who's the head of the Anti-Corruption Division. I recognize and present Honorable Justice John Eudes Keitirima, who is the head of the Family Division. I recognize and present Honorable Justice Michael Elubu, who is the head of the Criminal Division. I recognize and present the Honorable Justice Stephen Mubiru, who is the head of the Commercial Division. I recognize and present the Honorable Lady Justice Anne Mugenyi, who is the Deputy Head of the Commercial Division. I recognize and present Honorable Justice Asim Wetadeo, who is the Deputy Head of the Land Division. I recognize and present Honorable Justice Dr. Emmanuel Baguma, who is the Deputy Head of the Civil Division. I recognize and present the Honorable Justice Richard Wejuli Wabwire, who is the Judge of the Commercial Court, representing the head of the International Crimes Division this afternoon. I recognize and present Honorable Justice Thomas Ochaya, who is a judge in the Commercial Division. I also recognize and present the Honorable Lady Justice Linda Mugisha Tumsime, who is the Chief Judge of the Industrial Court. My lords, it's my pleasant duty this afternoon, as you will decide amongst yourselves, to respond. You have already received a cross-section of the matters that have been discussed today. You have had time to digest and to contemplate on your responses, and so it's my duty, my honor, to ask you, as you wish, to present your opinions in a much obliged, my lord. If we could have the microphones, please.
Thank you very much, the Honorable Attorney General, my Lord the Principal Judge, my Lords present, Senior Counsel present, members of the bar present, ladies and gentlemen. I'll begin by thanking the Uganda Law Society and the judiciary for availing us this forum, where we interact without any reprisals, and that is guaranteed. We thank you for the feedback we have received. We need this feedback, and as you will agree, no human being is infallible. Whether you're a judge, whether you're a senior advocate, or whether you're even a bishop, you are not infallible. So we are bound to make mistakes, and it's very important that we get this feedback, and we are very grateful for this arrangement. I'll react to some general observations, and then I'll be specific to some that have been raised about the family division. My name is John Eudes Keitirima, and I'm the head of the family division. I think we take judicial notice that the judiciary is overwhelmed by the work it has to dispense. There's no dispute about that. So we are still expected, though, to deliver to the expectations of our stakeholders. And I want to give some solutions. We know that we have had a perennial problem of judges. I'll give an example in the family division. The average workload of a judge in the family division is about 600 cases. Assuming everyone who files a case in this court wants a hearing date, which they always actually demand for, you're handling 600 cases. So it means, even if you are to fix these cases, first of all, the number of cases are beyond the calendar days we have in a year. Some of these cases will spill over to the next year. So what am I recommending? That we know that it will never be possible to avail the number of judicial officers we require in this country, but there are some solutions actually which are provided for in the Constitution. One, that it's actually possible for the government to retain judges who have retired. There is a provision in the law and in our Constitution that actually these judges can be retained, and they don't have to be used for the day-to-day work, because we appreciate they have reached that level where they need to retire, but at the same time, they could still be useful. For example, if you retain a judge on retirement, you could assign him cases, say under the category of backlog. You say, Judge X, handle the cases of 2018 and below in the family division. And that is possible. So that is a possibility. Two, there's been a problem of fixing of matters. Yes, I agree. Our approach in the family division is that we should prioritize old cases. The principle of first in and the principle of first in, first out. Otherwise, we shall leave justice to the vigilant. That you'll only attend to those people who are vigilant, who can come to the court and demand for hearing dates. So we are striking a balance and saying, yes, we have this perennial problem called backlog. These are old cases in the system. These are cases that are giving us a very bad name. We are prioritizing those cases, but we are still attending to some cases which are freshly registered. We have challenges of the human resource. We have very few clerks. We have very few process servers. The Judicial Service Commission has been given the mandate to recruit, but I don't think they have the capacity to recruit. So that's still a problem. And you actually find staff that have been to your division for more than 9 years. You can't believe it. People have served in one station for more than 5 years, and they take their jobs for granted. And if they're engaged in bad practices, you have to see how to manage that category of human resource. Innovations in the family division. Why is it that we have a notice today, we have a notice tomorrow, we have a notice the other day? The Succession Act has been recently amended, and with it, very new innovations have been introduced, and we are trying to grapple with them. You've heard from the Attorney General that we have not had regulations, so we are trying to grapple with some of these things. But most importantly, we are grappling with the fraud that happens in this division. I can assure you it's very disheartening if you realize that after giving out a grant, you realize that the processes that you went through to give out this grant were fraudulent. I'll give examples. We at times get people who appear before us applying for estates where the owners of those estates are still alive. That has happened. Somebody appears before you calling himself Keitirima when he's Arinitwe, simply because he can produce an ID before you identifying himself as Arinitwe. We have situations where certificates of no objections are forged. So we are saying, please, as an advocate who has been given instructions, don't take the paperwork at face value. You can do some due diligence. Are you dealing with the right person? Are the documents that have been given to you authentic? Otherwise, I can assure you the reason we have almost new practices on a daily basis is that we unearth fraud on a daily basis. And the legal regime, when you're carrying out due diligence, not everything in the law provides for that due diligence. There must be some practices. Like when you're buying land, I think the legal regime just says you go and carry out a search. But you know there's more to that. So, kindly bear with us. We shall improve our act, and then I think we should be able to deliver. Filing of inventories. This has come up because now when transactions are being effected by administrators of estates, there is a requirement, I think, in the Ministry of Lands that you should prove that you filed an inventory within the time frame. So we are now getting an avalanche of people applying to file inventories. You know that the law is very clear. An inventory should be filed within 6 months when you are given the grant. Now, if you have exceeded that time, how do you move court? If you have exceeded time, how do you move court? And by the way, there's even a Supreme Court decision on that. You must file an application for extension of time to file an inventory. Okay. I'll talk about the registrars because there's something specific about registrars and the human resource. With the innovations in the law, I think it's now almost necessary to have a registrar for each judge. You know the new innovations in the civil practice, in the civil procedure rules, the summons for directions, where most of the applications are handled at that stage by the registrar. Then there is administration, because the registrar is the administrator of the court. There is identification. There is taxation of costs. So they are a bit overwhelmed. My view is that the way forward is that we should at least, even if we can't recruit a registrar per judge, we should have a registrar to serve 2 judges. There was a problem, I think, Council, who talked about the jurisdiction of the magistrates with regard to divorce matters. We are getting a situation where decrees from the magistrates' courts are shunned by foreign jurisdictions. And now we are having the burden, or we are being requested to verify those decisions as High Court, which I have rejected. So that explains the reason why some people are coming to the High Court to file divorce matters there. Because I'm told when they go to the American Embassy or when they go to some European jurisdictions, they don't recognize those decrees. And I've said, I think they will have to find an administrative solution. I've actually referred people to the chief registrar to, I think, write a letter explaining some of these decisions, because we shall be overwhelmed. The other problem we are facing You see, with the nature of the family disputes we have, we try as much as possible to encourage mediation. But the advocates are shunning mediation for reasons I do not know. You see, matters of the family are by their very nature secret. You are actually doing a disservice to your client to have these matters in open court. We have an opportunity. We have said they are court accredited mediators, and we have made a deliberate policy in the division to refer most of these matters for mediation. But the reports we get, the mediation failed because advocates did not appear. Now the same comes to when reporting these matters on ULI. We have got requests from you and the parties we serve that because of the private nature of those matters, we should not publicize them on ULI. That A should not be found, or should not, the information on the grounds of divorce, for example, should not be availed to the public for consumption. We are still debating, but we have got those requests. Please keep these proceedings secret. We do not want them in the open. Now, I think with the complaints, I'd want to propose, and that's what we are going to do. I think we should open up some space, some office that will specifically receive complaints, because I'm surprised that it's very difficult for some people to have their documents signed. The only challenge I can see is that before you sign for the registrar to sign a document, the judge should have provided a hearing date. And at times, documents are delayed to be signed because of that reason. But when this is done, I think there should be no excuse for delay by the signings of the registrar and the other judicial officers. Now, I think with regard to, we also observe, by the way, that some advocates are taking matters so personal to the extent that when they lose before you, they don't even greet you. I've seen it in a few instances where you meet counsel and you say good morning and they don't respond. They are so annoyed by your decision. And that also happens in the courtroom. Why should an advocate exchange before your clients almost to the extent of fighting? This is a common feature. Almost to the extent of fighting. And I've actually been telling some of them that do we create a ring, a boxing fence, so that you first sort that out physically, then we return back to the matter? Use the power of reason, be calm, and show a good example to your clients. Let there be a difference between the court, a formal court, and the LC court. Of course, as a family division, I want to acknowledge that there is a challenge of recent, especially with the retrieval of documents. I think our archives have been undergoing a process of rearrangement. The exercise is still ongoing, but for those who have been in the family division, you even observe that we have a problem of space, to the extent that some of these files are actually kept in the court halls. Some are actually even kept out of the structures we have, simply because we don't have space. But there's a solution coming very soon, and we hope space will be created, and we should be able to serve you better. So I think that is basically it, and I want to appeal to you that some of these problems we encounter in our divisions can actually be resolved there. Don't rush to write to the principal judge when a solution can actually be found at the division. Attempt, and when you fail, that's when you can start, because now the practice is almost, we are responding to complaints addressed to the principal judge, when we are actually there to help you to resolve some of these problems. But yes, we acknowledge as human beings, we have made mistakes. There's always room for improvement, and we keep improving. I can assure you the judiciary arranges training programs, and some of the complaints that actually come from you is that most of the time we are attending these trainings and we are not available at the court. I want to thank you once again.
Thank you very much, Senior Counsel. My Lord, the Principal Judge, Honorable Attorney General, President of Uganda Law Society, Senior Counsel present, all members of the bar, I want to take this singular honor for giving me this maiden opportunity to interact with members of the bar since I believe the inception of and revamped operationalization of the industrial court. My colleagues at the High Court refer to our court as the court in the diaspora because of its uniqueness. I believe you're aware that the industrial court is a court of reference, unlike the High Court and other courts of judicature, and it's a court that is established under a statute, and particularly under Section 8 of the Labor Dispute Arbitration and Settlement Act, mainly to handle adjudication and arbitration of matters referred to it from the Labor Office. There was a complaint about magistrates' courts not doing our work. The law provides that our first court or first point of forum is the Labor Office. And so we are unique, and our challenges are also unique. I would like to adopt the general issues that my brother, my Lord John Ketirima has talked about in general terms, and I beg to be allowed to specifically look at the industrial court because there are quite a number of issues that were raised about us. The industrial court sits in form of panels. We sit as a panel, and a unique panel, by the way, of 4. Usually panels are supposed to be odd numbers, so that when there is conflict or there is a need for you to vote, then at least you can have the numbers. In our case, the court is presided over by a judge, sitting with lay persons, representative of employers, a representative of the workers, and an independent member that is appointed by the Ministry of Gender. By the way, I must emphasize that the court is situated in the Ministry of Gender. One leg in the Ministry of Gender, where we draw our operational funds, and the other in the judiciary, because the judicial officers are supervised by the principal judge and the Chief Justice. So we have to operate in both. And under the new program planning mode that has been applied now, we are both in the administration of justice program and also under the access to justice program under governance and democracy. That's a story for another day. But that shows you how unique we are. And so as a result, we had to, given that we're a court of reference, we handle whatever is referred to us. The first case load that we had in November 2014 when we started was handed down to us from the High Court. And these were over 400 cases, some of which we had to start de novo, some as old as 2011. I think the oldest was 2009. Now, what is interesting is that once a matter comes to the industrial court, it comes as a reference. But in essence, it starts as a court. It starts really the way it starts in a court of first instance, because the parties are required to file pleadings. They file claims, which are equivalent to plaints, and they find responses, which are equivalent to written statements of defense. And then, of course, we have to go through the scheduling. And I must say the industrial court has innovated around the issue of scheduling, whereas scheduling in the other courts is done together with a judge. We have innovated to try and abridge time to direct the lawyers to sit together and come up with joint scheduling memos, and then we only adopt the joint scheduling memo and move to fix the matter for hearing. So we don't sit down the way it is done in other courts of judicature. And we thought that was helpful, but recently, like His Lordship said, I had an incident where the court orderlies also had to come and save me from two lawyers fighting over failing to come together to come up with this joint scheduling memo, which made me believe that probably we may need to go back to sitting together with counsel. Since inception, we have had over 5,000 cases registered, and we are only 2 judges. To date, we have 2,700 cases in our docket that have to be handled by 2 judges and 1 registrar. The Labor Dispute Arbitration and Settlement Act was recently amended to provide for 5 judges and 3 registrars. But we are not able to have the 3 judges recruited because of mainly lack of resources, funds for the recruitment, but most importantly because of lack of space. We are situated in, we share premises with the National Councils for Youth and Women, and have no space to accommodate the 3 judges, even if we wanted to. The reason why we sit as a panel is that we apply the ILO tripartite nature of labor dispute resolution, and this panel is supposed to build consensus. The law does not provide for room for disagreement, but save for in exceptional circumstances where the judge will have to take the decision individually, but we have not had such scenarios to date. One of the issues that has been raised is about delays in delivery of court decisions and adjournments, and I take note of that. This has really been as a result of, I think, a lack of case management. We have not really had an opportunity to manage our caseload. But I would like to assure you that we have developed our own ICMIS. I want to call it ICMIS, Industrial Court MIS system, that has been developed in-house, and it has enabled us to identify the number of cases, the status of cases. Each judge has a dashboard. We have a screen in our chambers that shows you your caseload, shows you the status of the cases, what is pending for judgment, and so we are now beginning to offload them in terms of delivery based on age. One of the comments was that we are very reluctant to weed out cases for want of prosecution. I would like to report that this is ongoing. So far, we have considered over 120 cases and only managed to weed out about 40 because the parties actually were able to come up when we listed these cases for a weeding out exercise. One of the reasons that delays is that we have, because we inherited a very big workload, we decided to use the pre-session method. So in terms of pre-session, cases are collected and we only have pre-session hearings after we have collected a number of cases that we believe are ready to proceed. And of course, given the uniqueness of our court, we also had challenges with the rules. And I'm happy to report that this week on 12th, we are going to confirm and complete a process that has been undergoing of reviewing our procedures, our court procedures, to harmonize them with the civil procedure rules as amended, but taking specific cognizance of the method in which our court is supposed to operate. So we have simplified the procedures, but tried to create harmony with the CPR so that we don't deviate too much, or much as we are a court of equity. We have also put in place directions on how to file matters in our court, which we are going to disseminate soon, because there is a complaint about the fact that there is a lot of delays and costs on litigants because they have to replicate their pleadings. We expect that each litigant is supposed to file at least 6 copies of their pleadings, and they bear the cost. And one of the issues that has been raised is that this is very expensive and also a bar to access to justice. But on the other hand, our court does not charge fees for filing pleadings. So you don't file any fees. And so on a balance, really, if you don't file any fees, you can at least incur the costs of replicating these documents. In any case, we do not have that budget that would enable us replicate these pleadings to enable each member of the court receive their copy or their file. There has been a complaint about the industrial court in Jinja. I must say that the industrial court is only based in Kampala. We do not have circuits yet. We hope there will be circuits. But we have been circuiting in different regions where there is need. We have done circuits in Fort Portal, Gulu, Lira, Mbale, and Jinja. And Jinja actually has the biggest caseload in terms of the work we handle. But to address this, we also set up sub-registries. In almost all the divisions, we have sub-registries in Mubende, Mbarara, Lila, Guru, Jinja, Mbale, and Fort Portal. And these sub-registries at the moment have been, I would say, this is really an arrangement between us and the different circuits. They have lent us space and their staff to help us do this work. That is to file cases for labor disputes on our behalf. The challenge has been that the clerks that assist us in these divisions also have their work already. They already have their own workload. And so the attention to these sub-registries has not been strong enough. So what the industrial court has done is we requested public service to expand our administrative structure to include a provision for appointment of clerks to man these circuits, which we believe will help us. Now, the issue in Jinja is Jinja does not have an industrial court. It's not an industrial court. We have held a number of circuits. I think it's the most visited. That is 3 of them. And currently we are told, according to the the statistics that were sent to us from the sub-registry, there are over 80 cases that have been filed, and we are planning to go to Jinja for a month, at least for the month of June. I must also emphasize that the circuiting is something that we can only do if we have the money. We don't have the budget. The circuits that we started were done with the assistance of the Justice, Law and Elder sector that extended to us some funds to do the case weeding out, to establish those very sub-registries, and to carry out the circuits. So the problem is being addressed, and as a means of trying to reduce the time taken by the judges, her worship, and I would like to recognize her, just I call her the CR of the Industrial Court, Sylvia Nabagala is here today, is going to go ahead of the court to do the equivalent of summons for directions before the court can go and sit to hear those cases, so that we do not waste time with persons or matters that are not ready. Just sit down and hear those that are ready, deliver judgments, and come back to the center. So the long period which the court takes to fix matters is really as a result of the nature of cases we have, the way we are supposed to handle them, and the way they are, the structure and the procedures that were set in the law on how we are supposed to handle them as a panel. Because when we hear a matter, we have to sit down as a panel, the panel must sit down and build consensus before a matter is delivered. And sometimes when we do adjournments, we adjourn because the panel has not yet built consensus. There's still disagreement, and the judge has the role really to explain to the panel maybe issues of law, and because I mean they are lay persons, so you have to really convince them that this is the law. And one of the challenges also was that these panel members came and were sitting really as constituent members. They are not looking at themselves as judges. So a person who is representing an employee will fight tooth and nail to make sure that the employee succeeds in this matter, notwithstanding the facts that are before us. So the issue of objectivity has taken time to build, that each panel member is fighting to see that the workers win, and if they don't win, I am going to be castigated by my membership, those that nominated me. The employer also is struggling to make sure that the employer is winning, because they know to and cough to are going to actually penalize him or her. And so we had to also go back now and try also to sensitize the trade unions and the Federation of Uganda Employers to appreciate that once they nominate these persons, they are sitting as judges, not as members of the different constituencies. And that too also delays the decision making. Yes, indeed, we have a problem with regard to the staffing. At the moment, we don't have staff, administrative staff that we have are all working on temporary contracts, because we've just had our administrative structure approved. It had to be amended because of the need to have the extra clerks, to have a PRO and other staff. And now we are in a quagmire because there is a ban on recruitment. We don't even have a wage bill yet. We wanted to go and now argue after getting our administrative structure. We wanted to argue for a wage bill, but then we have this problem that there has been a ban on recruitment, and so that becomes a challenge, especially with regard to recruitment of staff. Our registrar is currently overwhelmed with a lot of work. She has to do judicial work, administrative work, and she also has to play the liaison role between us, between the court, the judiciary, and the Minister of Gender, and that takes a lot of time. So that is one of the reasons why she's probably not sitting to complete her judicial work, because she has to keep rotating between the different institutions to keep the work moving. So I believe we have also completed our strategic planning, which we shall share with you shortly soon, my Lord the PJ and Honorable Attorney General. We realize that given our uniqueness and the way we are situated, and the fact that, for instance, in Ministry of Gender, we do not fit very well, and the courts of judicature do not also appreciate the fact that we sit with lay persons, we are, like they said, in the diaspora. So we have to create and show our uniqueness, and so we have come up with our strategic plan and our strategic direction, showing our strengths, the reason why we should remain unique, but also calling for giving a bigger share of the cake at the table so that we can do our work better, especially in terms of getting more judicial officers. We need more than 5. Maybe in future, adopting what South Africa has done to cascade and have an appellate division of labor, because labor disputes are actually on the rise. At the moment, each judge has a caseload of 1,400 plus cases, and which we can only complete in 6 years, if given the time, in 6 years' time. But if you gave us the 3 other judges, this time could reduce to about 1 year and 2 months per judge. So we really call upon you to support us. I would like to take this opportunity to thank the members of the bar. We have been learning together. Our laws have had a number of issues. They need harmonization. Currently, the Employment Act is undergoing amendment, and I would like to thank the members of the bar who shared with us their comments and inputs into strengthening the Employment Act. And I believe if those comments that you sent to Parliament are put in place by Parliament, we'll have a more robust Employment Act, and the labor dispute regime really will be strengthened. Yes, like His Lordship said, the Judicial Service Commission has the mandate to recruit judges for the industrial court, but they will still need resources, and we still need space to accommodate them. So I'm calling upon you, my Lord, the Principal Judge, and most importantly, the Attorney General, to take cognizance of our needs so that we can expedite our role. I believe I have addressed the issues. The issues was mainly the industrial court in Jinja. It does not exist. It is just the cases that have been filed as a result of the sub-registry that we established. We are planning to handle as many as possible. Yes, it's true, we have limited justices to handle the cases. That the fixing of matters is being improved with our ICMIS, with the new practice directions, with the improvement of the rules, which we are going to share with you in a couple of weeks, because they are completed. We have the Court Users Committee, on which members of the bar sit, and that has really given us invaluable advice and direction, for which we are very grateful, and we want to take this opportunity to thank the members of the bar that sit on our Court Users Committee, majority of whom actually comprise the Industrial Court Rules Committee. I beg to stop here, and thank you very much.
Thank you. Honorable Attorney General, my Lord the Principal Judge, President Law Society, my colleagues, Council, in your Council present and online. I want to thank you for giving us this opportunity to interact with you. I've agreed with my colleagues who have not spoken that we are not going to spend more than 20 minutes. So just to put you into proper perspective, we are going to just react to those issues that were raised, and not more than that. And I personally am going to take less than 3 minutes. My Lord PJ, these are the issues that we should be discussing at our judges' conference. The lawyers have brought out these matters properly. But when we are drawing up a judges' conference program, we tend to do for ourselves. We should do for the public that we serve, not for ourselves. We integrated personal assistants to help us do research and perhaps draft 1 or 2 things. These are magistrates grade 1s. They have no experience. I am not surprised when those that consume our product say that the judgments are having a challenge. This is part of the problem. We integrated magistrates grade 1s in our service as PAs without the attendant training, without the attendant guidelines. So we need to discuss this. Otherwise, principally they are supposed to be applying the Magistrates Courts Act. Wherever they are deployed, whether in the Court of Appeal or Supreme Court or High Court, they are supposed to be doing that. The issues of judgments and formats and so on, I think we need an internal debate on that one, on how to do them. Issues of stare decisis, yes. It's not only the advocates who are experiencing the problems, but also to us, to whom you present those judgments. There are time-tested decisions by the Supreme Court where we think issues are rested. But then you find another judgment bringing up something, trying to create, to reinvent a wheel and try to modify something. And we also, as judges, sometimes have those challenges. So stare decisis is something we should discuss also internally. Late Justice Maniragua's cases were raised. I think we have a challenge. We can discuss that. Using my institutional memory, I know that the late had that practice, call it a practice, of say file written submissions. Then he discovered that the bundle is too big. Unfortunately, he passed on before he could tackle. So those cases were brought to Kampala to be distributed amongst judges of the High Court to write the judgments of the late. Some judges wrote those judgments. Some judges declined. They said there are judges in Mbarara who should write judgments for their colleague. So while I was a resident judge in Mbarara, I came looking for some of those files. I picked about 10 that I could land on, and I wrote those judgments while I was in Mbarara. The other judgments, we cannot trace the files. They couldn't trace the files because they were in the High Court Kampala. So I think I have provided some information from where you can follow up. Judgments on notice is something we can discuss internally as a judiciary. Our Judicial Code of Conduct does not have judgment on notice. We at the Anti-Corruption Division, perhaps we are the only division with case management rules. Legal notice number 11 of 2021. If you Google case management rules, ACD, it will come and takes care of this. It tells us 60 days, so we don't have that problem. So we don't have judgment or not. So we don't know where it comes from, but it is something we should discuss internally at the judges' conference. It is not provided for. See, lastly, the ICD, and perhaps somebody is representing the ICD. I have said, I think we domesticated the Rome Statute. But the Rome Statute has a huge budget. I wish we had created the ICD within the Rome Statute, rather than creating the ICD administratively as a division of the High Court. For instance, the ICD will ask for 500 million shillings to go and do sensitization. Sensitization, and you bring no return. The money people, if they give 500 million to criminal division, they bring back a return of so many cases completed. You see, so now we are comparing the incomparable. The ICD, with the greatest respect, in my view, is in the wrong place. It should be having its own statute and its own budget and running its business. That's how it can be. So, Mr. Kabega, Council, that case requires resources. And when the resources come, we can't accept for ICD to take all those resources. ACD wants some, civil, criminal, everybody. So when we give them the money, it looks too little for their business, too little. And at the end of the year, they have no return. They have not completed the case. Thank you very much.
My Lord, the Principal Judge, Honorable Attorney General, Your Lordships, Your Worship, the CR, the President, Uganda Law Society, members of the bar, I'm reacting to some comments and questions and observations about the commercial division. I have the benefit of a write-up that was presented to me, and I've selected 5 areas to cover in this response. I'm fortunate that on 17th of February this year, we had a similar interaction with the bar. Therefore, I'm highlighting some of the issues that we've addressed and some teething or remaining issues. The first category of 12 comments is on ICMIS. The concerns are about judicial officers not using it adequately, delay in validation, delayed responses to communication, delays in registration of cases, delays in fixing dates, and allocation. Our observation in the division is that ICMIS is a tool. Like any tool, it has its limitations, which can be improved upon and customized to suit the job to which it is assigned. We've identified some areas that require customization. For example, in the division, we need to categorize cases by type. In trade, construction, banking, it's not possible at the moment. Therefore, we are recommending that these improvements are done. But even before the improvements, being a tool, if you are a bad workman, you tend to blame the tool. I've found, I'll give myself as an example. When ICMIS was introduced in March, I tried it for 2 days. I found it too slow. I abandoned it. I did not go back to ICMIS until July last year. I decided and made a conscious effort to make the tool work for me. I have not looked back since then. I can't do without ICMIS anymore. So using the tool takes personal effort. We can't keep on blaming it until we actually get our hands to use it and see where it is working and not working for us. These are observations. As judges, we keep on encouraging one another to improve our skills in using the tool, but we've observed that from the bar, there are also shortcomings. Just before I came here, I interacted with the deputy registrar, and we discovered there are over 500 pending validations of pleadings. And the problem is common to all of them. I think there are two problems with the 500. In one category, you have pleadings without payment of fees. In the other category, you have submission of a filing without attaching the pleadings. Comments were made in some cases months ago. There is no response yet from the advocates, which indicated to us they are not using the tool because the comments are clear. Before you validate, there is a dialog box that enables you to make comments. And when we find these shortcomings, we insert those comments, but there is no response. So, members of the bar, I think there has to be an incentive for the members to use the tool. There should be a series of trainings to which you attach CLE points to attract these members to learn to use it. You can't do it remotely. I've tried it in court to ask an advocate to open ICMIS and show me their pleadings. Then they say, but it's the clerk who does it. So the advocate has not used it, but is complaining in court. The pleadings were filed, but they are not visible on the system. So all of us have a challenge. We must face this challenge and find solutions. We need to improve our skills. That answers the questions raised about ICMIS. It is not going away, as Council Mutavingwa pointed out. We have that response all the time. It is us to improve our skills in using the tool. The second category of concerns are about the operations in the registry and the way the deputy registrar goes about her business. They relate to her personality. Some people have found it difficult. I'm using a lighter expression. The wordings were so strong. Sometimes she's not objective because of that limitation in her personality that has been mentioned. She's monopolizing all pleadings and processes to the exclusion of other registrars. The disposal rate is very low. You are kept waiting for long periods of time outside the office. It is very difficult to secure dates before the registry and the registrars. And there are slow responses from that office. First, issues of personality. I think we all have skills of interacting with all manner of people, irrespective of their tendencies. I don't have an answer to that, but in case it is too bad, I think we can engage as a team and address these and encourage better working relations. As regards centralizing all processes to her, we experienced a breach of our system. It was abused by some people who had access in terms of allocation of cases, assessment of fees, and quite a number of other misdeeds. Once we discovered this, we reported to the ICBIS team. They did a forensic examination of the system, identified some of the abusers of the system, and we made recommendations on how it can be addressed. But before the technicians come in to make it more secure, this is a stopgap mechanism. It's for a short time. But once those security measures have been put in place, it will be open to the other registrars and clerks to perform their roles. So we request you to bear with us as we sort out that breach. Now she's overwhelmed as a judicial officer. She has to do judicial work, at the same time administrative work. Our recommendation is that the business of the division is so voluminous that we must have a distinction between administration and judicial work. I think we need a judicial officer doing purely administrative work, receiving documents, signing them, transmitting them to the various judges, giving feedback, and not doing any other judicial work, writing rulings, for example. Right now, she has to do both. Same with the head of the division and the deputy head. As we do administrative work, we're also expected to meet our targets in terms of resolution of disputes. And it's very difficult to balance because the time for administration is too demanding. Many times when you go into the chambers in the morning, you find 5 or more people waiting to attend to their business. And that takes about an hour or 2 even before you go into court. So it's time consuming. So these are problems we are grappling with, but we shall find solutions very soon. The third category of concerns is to do with clerks, clerical staff, and other support staff like security personnel. They are rude on many occasions. They are unresponsive at times and slow in performing their duties. One example that was given, taking 5 minutes to open a gate. You are waiting at the gate for 5 minutes and it can't be opened. You seek service of a clerk and the response is a rude remark. Unfortunately, one comment that came in that some judges don't seem to respond in a timely fashion and appear to be supporting their clerks when they mistreat court users. My request is that you bring these occurrences to the attention of the head of division and the deputy head. We have internal mechanisms for dealing with these types of behaviors and calling these members of staff to order. So we shall deal with it, but they are also undergoing training on, I forget the expression now, customer care. They are undergoing training by JTI in customer care, and some of them have been exposed to this training. We expect that they will improve in their performance. The last category were general concerns I failed to categorize. I'll isolate them one at a time. Parking space is limited. The suggestion is that judges share their parking space with advocates. Unfortunately, the space is limited, and that is not possible because now we have 2 more judges and we expect more in case there's new recruitment, and the space is already limited. So it is reserved for judicial officers. You have to improvise. There's nothing we can do about it. Communication between the court and the bar, especially when the activities, yes, we've taken up this point, and we have the registrar to communicate on our behalf whenever a judge will not be available for whatever reason, for as long as there's ample time to give notice. Sometimes the occurrences are too sudden that there's no time to give notice, for which we regret any inconveniences that result from such behavior. The other concern is poor quality of decisions. It is very difficult to find time to write judgments and rulings. That is a fact. if you've observed this court, sometimes we sit in court from 9 to past 4, sometimes past 5, without a break. You don't even go out for lunch. You are in court for all those hours. Then you retire and have to write rulings and judgments. You also have other matters to attend to of a personal nature. There is hardly any time. I try to do it personally, writing judgments and rulings and hearings. It was impossible. I dropped that approach. I decided to create time by disposing of all applications that were on my docket to free up time, and it has worked. I now am able to dispose of applications that come to me within a month of filing. You file your application, you have a ruling within a month. But those waiting for judgments have suffered. But I now have time to write judgments. That is one mechanism. So individually, we try to create ways of freeing time to write judgments. The other method we've adopted is creating sessions. We devote our time to a particular type of case for a quarter. That helps us to weed out non-starters in that quarter. You focus on one area of practice. Therefore, the research you do is still fresh in your mind and can be applied in many cases of a similar type. It takes a shorter time to write decisions. We are experimenting with it, and I know there are people who are against it. I've seen some comments here because they see their cases are delaying, they can't find dates. But it is still a mechanism that we are using to streamline the little time that we have, rationalize it, and make sure that we use it efficiently. Lastly, in the general comments, is fixing cases at the same time. More than 2 or 3 cases at 9. And some people have to wait until 1 or beyond 1 for a case that was fixed at 9. It's unfortunate and we regret it. But this is an informed decision. In the past, you would fix a case at 9, another case at 10, another at 11. The case fixed at 9, you are in court, there is no one in court. They come in at 9:30 and seek an adjournment. That hour has been wasted. Yet you have 700 cases in your docket which demand for time. So you have to balance the demand for this limited time with the number of cases that you have and the possibility that people will proceed with their cases. So you use the shotgun approach. Have many cases, at least 2 of them will occupy you for that time. Even if 3 fail, you'll be occupied by 2 that will take off. But gradually, the number of adjournments are reducing. Advocates are now better prepared, which I commend you for. We are now in a position to stagger the cases once again because you are sure these advocates will come prepared with their witnesses and will be able to proceed. The time will not be wasted. We will be reverting back to that system in a short period of time. But for the time being, we apologize for the inconveniences and regret it, but it was a mechanism for ensuring that we don't waste time in the division. I think that is it, and I thank you for listening to me.
At this juncture, my Lord, I would like us perhaps to take a 10 minutes health break. I'm conscious that that we may need that 10 minutes, and we shall resume immediately thereafter for my lords to make their last concluding remarks. Justice Tadeo? Yes, certainly, my lord. My lord, I'll exercise. Yes, you can also have some tea at the back as you come in. Much obliged, my lord.
discussed them and agreed on the way forward. So I will mention those concerns and the way forward. Number one, absenteeism. The issue of absenteeism or absence of some judicial officers from duty came up. It is true, sometimes because of different engagements, we found ourselves not being at the station. However, as a solution to this, or solve this problem of absenteeism, we said we shall improve on the communication channel. As civil division, we shall post some notices on Advocates Forum to inform you that Judge A will not be available at the station. We also said that to solve this problem of absenteeism, phone calls will be made directly to advocates handling particular cases before a particular judge. So we shall have courtesy through the deputy registrar and clerks to post those notices on civil division forum and make phone calls. Certainly judges are not angels. They also have some both official and private engagements, but we shall improve by communicating in advance. Two, that matters take long to be heard or concluded. As you have heard in some communications, there is a need to add some judges in civil division. In civil division, we have 5 judges. Each judge has about 600 and above cases. So, to fix a matter within a nearby date, sometimes it is not easy. The nature of cases in civil division also are very challenging. You know, civil division is one of the divisions that any advocate will find it comfortable to file any matter which doesn't belong in ICD, which doesn't belong in commercial court. They package all the nature of cases to fit in a civil division. But out of those 600 cases before each judge, at least when you look at the monthly returns for individual judge, you find that we are out in the range of 30 cases per month. And we say we are trying our best. So, although matters take long to be heard or concluded, it's because of the nature of the cases in civil division. When I talk about the nature of cases in civil division, we are overwhelmed sometimes with judicial review cases. They have time frame. We have enforcement of human rights. All this, they come with a time frame that should be completed within this particular time. So when you try to concentrate on judicial review or enforcement of human rights, ordinary matters, the lawyers are complaining. But we try to balance the boat. There is another issue also that it is very hard to fix a matter in civil division. As a division, we have sat and decided to create hope to lawyers and parties that at least instead of receiving many letters requesting for dates, let us agree with the lawyers that in these ordinary suits, file witness statements, Then you come for cross-examination. Basing on that, we agree that let us now put this matter in November. What do you see the following day? Now we have social media. That my case, Judge so-and-so has adjourned it 7 months ahead. Now, remember, these are the lawyers who are saying, at least give me a date to create hope. So when you try to create hope, then here you are criticized that you are giving wrong adjournment. When you say, let me first handle this, then they are criticizing you that it is difficult to get a date. But we're in civil division, we are trying with certainty to give people hope so that at least each case gets a date, though we consider first in, first out. Another issue is on delayed rulings and judgments. Yes, in some cases it is two-way. Sometimes judges are transferred. When they are transferred, they go with pending rulings and judgments. Where they are going, also, there is work. So, in most cases, you find that those transfers in civil division, we have those pending judgments and rulings as a result of transfers. But equally, we have pending rulings and judgments before the judges who are there, but steps are taken to ensure that rulings and judgments are delivered on time. Another concern, an courtesy of some judges, or lack of respect of judges to the bar. It is very unfortunate to have such scenarios because respect is a key. And we should have courtesy to each other. We have decided in civil division to use peer groups. We talk about ourselves basing on the feedback we are getting. So we are trying to see that we should promote courtesy to each other. But again, there are some situations which may be mistaken. For instance, you get an advocate, you are proceeding, he's trying to cross-examine a witness. He says, look at this document. The document has 10 pages. Read it to court. Now, you say, what is your question? No, let him read it to court. No, but you say, counsel, okay, which page do you want to raise a question? I'm saying, let the witness read the document to court. Okay, you are wrong. Now, you are trying to be in charge of your court, but you want to be courteous. At the end of reading 10 pages, the advocate says, no question. And yet, he has taken all that time, you are trying. So, but that is also another challenge. But the bottom line is, we should have respect to each other. There is a concern that some judicial officers and even registrars, they are engaged in different activities, and this affect their work. Yes, sometimes both judges and registrars get engaged in different activities, but which are official. But here we have tried to request the office of the PJ and chief registrar, at least for registrars to add some registrars in case, for instance, if we have one registrar engaged in one activity, another one can chip in. So we are trying to balance the boat. There is an issue of corruption. Now, I want to propose on this issue of corruption. It is general, but I want to propose that on this issue of corruption, if we are to fight it, let us be bold. Senior Counsel John Mary Mugisha, you have said that some of the judges were your students. Be bold, approach Baguma and say, they are saying you have taken money in this file. Let us have bold people. We have law society. Feel free if we want to fight this corruption, because it is two-way. I think Council Mutabingwa said the way it is done, it's like adultery. But let us be bold and open. Council Senior Sebatindla, Judicial Service Commission trains all these judges. Feel free to call Baguma that they are saying in this file, money has exchanged hands, so that we are fighting it together. Senior judges, my brother Judge Giduda, I think, has gone out. If you know that a certain judge is shaming you or shaming the judiciary, let us approach each other as peer groups, mentorship, and then we shall fight this corruption. Conclusion of my remarks in civil division. Mine is a request and an appeal for implementation of these resolutions. Let us have implementation. These problems we have discussed here, they cut across. A judge in Mbarara, Moroto, you will find that these are same issues. So let us try to make implementations of these resolutions, and then the bar bench develop them as the best practices for the whole judiciary. Judges are like water in the glass. When you put water in the glass, you will be able to see all the contents. So let us know as judges that we are like water in the glass. Whatever we are doing, wherever we go, I think we are like water in the glass. Thank you very much.
Thank you very much. Allow me to adopt the protocol that has been observed here before. So I'll just go straight into some of the remarks that I had put down to respond specifically about the criminal division. There are some general areas that were laid out by Senior Counsel Mr. Drico. The first one was on corruption. There are some people who have complained about corruption in the criminal division. Now, the way we are trying to address this issue of corruption in the criminal division is to implement what we call the daily hearings. The traditional mechanism for handling criminal cases in the High Court is using the session system. But for the criminal division, we want to move away from the session system and adopt a mechanism for hearing cases on a daily basis. Now, what that does is it eliminates some of the avenues by which corruption can creep into the system. I'll give you an example. When you have the daily hearings, we've set up what we call case clearance teams. These case clearance teams have players from across the criminal justice system. In the past, to cause list a case, many of the accused persons were being asked for 300,000 shillings to have themselves placed on the cause list. But because of the daily hearings, the cause listing is done jointly. All the players, that is people from the defense counsel, the prosecutors, the court staff themselves, the judge, prisons, all sit down and agree on which cases they are going to hear on the basis of first in, first out. What that has done, it has eliminated the question of everybody trying to see how they can get themselves on the cause list. So through the daily hearings, I think we are addressing corruption. The other thing that the daily hearings has done for us is to create accountability amongst the judicial officers themselves. On every Monday at lunchtime, amongst the judges themselves, we look at the performance of the judge in the past week. And what that does is it creates peer pressure amongst the judges to ensure that when your cases are looked at on Monday, you don't have a zero. So I think that is one of the ways that we have increased on the performance of the criminal division. We have cause listing of the cases of all categories. What happened in the past is that if you had a session, that one particular judge would be taken away from hearing cases of other categories, even if the judge himself was sitting in the criminal division. But because you're having the daily hearings, cases of all categories are now heard at the same time. So if you've decided to have 20 cases in the month of April, 12 of those cases will be session cases, but 3 may be bail applications, the other 3 may be reviews. So what that has done is that cases are all categories of cases are moving at the same time. That used not to happen in the past in the criminal division. So in essence, what I'm saying is, I know our time is fast spent, it's already 6. Through the hearing of cases on a daily basis, we have, 1, increased the disposal rate in the criminal division. We have reduced on corruption, and we are also specifically addressing the question of backlog. So that's as much as I'll say about that. There is a cross-cutting question about parking space at the High Court. You know, the criminal division happens to sit at the High Court. That is the high headquarters of the entire judiciary of Uganda. So as the judiciary has grown, the administrative arm of the judiciary has also grown in numbers, and they have slowly eaten away the space, parking space, and all these other issues that arise with the numbers growing. So I want to appeal to the Attorney General. There is a proposed High Court space called the Jealous House. And that Jealous House is supposed to have all categories of courts housed in one space. And it's supposed to remove this whole question of lack of space. So I would request you to follow up and to push very hard on this question of the Jealous House. I think the Jealous House is supposed to be housed in Nakawa. And now that the space for the Court of Appeal and the Supreme Court has gone up, I think the next thing that should be done is to ensure that the Jealous House, especially the space for the High Court divisions, goes up. That should be able to address our question of parking space. Somebody talked specifically about the Koyelo case in the matrix that I was given. But I will not speak specifically about the Koyelo case. I will speak specifically about the International Crimes Division, because I happen to handle some of the cases that come from the International Crimes Division. The thing about the International Crimes Division is that it uses a hybrid system. We have tried to put together, or they try to put together, the international mechanisms for handling international criminal law cases, and also handle them as a hybrid using the Trial Indictments Act. So it's a hybrid. Now, by the time a case in the ICD comes for hearing, it is already backlog. That case has to go through the committal process from arrest. That may take a year or two. After the committal process, it has to go through the pretrial process. That may take another 2 years. After the pretrial process has been concluded and charges have been confirmed, it may then go for trial. Many times the trial is handled in panels. Because the trial is handled in panels, the judges are drawn from other divisions of the High Court. Sometimes Justice Mubiru has to come from the commercial division. I come from the criminal division. Other judges come. Justice Gaswaga comes in from the circuit in Lira. Now, while they are away for that 1 month that you're handling ICD cases, their own divisions suffer. So I think we need to rethink the way we handle the cases in the ICD. Is it really feasible for us to continue with this hybrid in the way that we handle those cases of international crimes? Remember that some of these cases are not really as complicated. I'll give you an example of some of these trafficking in persons cases. They are taken to the ICD, and they have to go through this entire system. Now, if they had been handled as an ordinary defilement case, by the time the person has served 5 years of his sentence, the person in the ICD is only just coming to trial, having his charges confirmed. So a rethink of the way we handle international criminal law cases is urgently called for. I think, lastly, I'll talk about how the office of the DPP and their current status is affecting the way criminal cases are running in the country. The office of the DPP has had a very high turnover of state attorneys in the last maybe 5-6 years. They have not recruited, and there's been a hemorrhage of prosecutors, especially to the judiciary. Now, again, I will appeal to the Attorney General here. We need to address that particular issue because it is affecting the way criminal justice is being handled in this country. The cases, criminal cases are delaying. They're not delaying only in Kampala, they're delaying across the country. The DPP is having to juggle deployment of state attorneys, and it is it has reached a crisis level right now. So I think they need that support. I think at a policy and political level, one, to open up, I think, to remove the moratorium on recruitment, and also to assist them, I think, to raise the numbers now that they have gotten assurances, I think, of a tax waiver. I think I would want to stop here. All the other areas I had wanted to tackle have been dealt with by my colleagues, especially the general questions. So allow me to stop here so that we can have time for the last two presentations. Thank you very much.
I would like to ask the Honorable the Chief Registrar. Oh, yes, Justice Tadeo. I beg your pardon, my Lord.
Of course, my Lord, the Honorable, the Principal Judge, the Honorable Attorney General, my colleagues, and the judges of the High Court and the advocates, as you can see, I'm not anywhere near the head of the division. You know very well the head of the division is Justice Nkonge. I'm not near there by appearance. So I'm delegated to represent her here. She sent her apologies, my Lord PJ. She's unable to be here today. Now, land division, we're not here to educate you about land division. You know it very well. But my Lord PJ, allow me use the language of being a former prosecutor. The indictment against the land division is 6-paged, and it has 36 counts. My Lord PJ, I'm here to plead guilty to the majority of these counts. If you have a copy for land division members, I'm here to plead guilty to all the counts except number 4, number 5, number 9, number 14, and number 15, 20, 22. That means I will respond only to those few, because the rest I have pleaded what? You are free to sentence us. And once I say I plead guilty, I agree with the proposals which came from the bar. Therefore, allow me go straight to where I do not agree, and we share our opinions. Number 4, failure of judges to allocate hearing dates for cases over a year. So for land division, you don't get a hearing date over a year. My lords and members, colleagues, first of all, I belong to a school of law of thinking that dates, this generosity of throwing dates, first of all, my personal opinion is that we shouldn't be throwing dates. What are you giving to people to say, come in November, on 1st of November, when you don't know even the PJ will put there a workshop? Do you have control over dates you have thrown to lawyers all over? I'm told, my lord, some of us have given dates in January. Yes, I'm told some of us have given dates next year in January. But I'm here to tell you, my lords and colleagues, to share what I've gone through. First of all, to get a date in my court, I've been indicted here. It's not easy. And I plead guilty, but for a good reason. We're here to share. Since my appointment, if there is an advocate who is demanding a judgment as old as 2 months, you put up your hand and I give it to you tomorrow. 2 months like this doesn't exist on my table. How? What is the magic? I don't give you, my Lord PJ, my latest longest hearing date in my diary is 6th of June. Because I've refused generosity of giving dates. I've done what? I have refused. How do I do it? I summon all advocates and their clients to appear before me administratively and get concrete dates every day from 7 to 8:49. Every day from 7 to 8:59. So once I give you my date, you can't play around with it because it's a moving train. I give you Monday, you don't come, you come and look for the date next year because you have wasted your date. So we agree, because we have signed an oral agreement that your case is Monday. You sign, I sign orally, and you miss to come. You see what will happen. Because for you, the train will pass you, I go to the next person. It will pass you, I go to the next person. And once I record PW1, I will not stop writing and release your file until judgment. That's how I do it. And the lawyers who have come know. Until I write the last defense witness, I don't release you. Some have started running to say, just today I said, bring all your witnesses on Monday. And it is an indictment before the PJ. Judge has said, bring all your witnesses on Monday. and the PJ has to handle that. So I pitied the PJ. But the point is, summoning people to get dates is to ensure that dates are not given for the sake of giving. I give you a date over which I have control, and even when I wake up in the morning, I know I have a case, not to do guesswork. I finish the case, write judgment. I am not in the... speaking for myself, I told myself and the people who come that I'm not in the judiciary to decorate files. Last week I was hearing a case, the judge who recorded evidence of PW1 is now in the Supreme Court. Evidence of PW1 is on record, and I said, I'm not ready to do this. We either begin or we don't begin. That's the practice. However, the indictment in this document is there are those lawyers who are not willing to come even when they say the judge wants you. So there is that lawyer who does not want to come. So thank you, bar bench meeting. I'm going to find a remedy for that category because I'll force them to come. So for those lawyers who fall in that category, your days are also numbered. You will come by force. Because for me, I even issue warrants. In civil, I issue. You don't come, I issue. And they come running. Now, the other issue is number 4, count number 4. The adversarial proceedings are not understood by judges. The proposal is that the judges should listen and allow the advocates to do their duty. Who tells you that? I'm in charge of the record. That I fold my hands, you drive me to Boyogere when I should be going to Nansana? I will not accept. This proposal, I have a problem with it. That a judge shuts up his or her mouth and the advocate takes over. Colleagues, this is not right, really. Because I'm in charge of my record, and therefore, if you are going outside your pleadings, my duty is to do what? To bring you back, so that you don't confuse my decision making. You don't raid me. So this proposal, I find a problem with it. Members, you can deliberate and advise. Since we are going to form a matrix to make proposals, my input is the court must have control and the direction the matter is taking, not to allow an advocate to raid you where he or she wants. It is a proposal here, so I have a problem with it. Somebody is proposing count number 9. Let's have dates issued for the cases as soon as the judicial officer is appointed to avoid back and forth running. Again, it goes to the same thing, throwing dates. I cannot throw my dates, my lords. My colleagues in the division who are sympathetic to these proposals have given you dates. But I want you at the end of the year to come and we compare notes where they have thrown dates to you and what you have benefited out of them. In terms of outputs, you return and we compare. Whether you have benefited from a date of January 2024 and my date, the longest of 6 June, where I have control over. So the possibility that I will be out of the country in January is also high. So you lose that date in January, by the time you realize you are in June, no hearing. So you find the files decorated adjournments. Actually, if you want to count dates of adjournments in my court, the statistics of adjournment and statistics of judgment, judgments and rulings are higher than adjournments. Come and do research on my table. Now, that let's have dates issued. Now that one we're finished. Another count that we are reallocate all the files before a Sikh judge
until the judge recovers. This is another problematic thing because each one of us is carrying a portfolio of 1,000 cases per judge. So you get the 1,000 cases and give them to the others because the judge is sick. Practically, this causes problems. And we have been reallocating the deserving ones. The head of the division has the mandate to reallocate the deserving ones. Of course, we know those ones. We tell you to rate and attach reasons. And reasons must be reasonable. You don't say, I want my case to be heard first. So that becomes a problem. Somebody is proposing routine transfer of the clerks who are problematic. For us, we say, you are transferring the problem to which court? Where you will not go. Remember, you are the same person appearing in those courts. My proposal, colleagues, would be, let's deal with the problem. We should, for me, I refer to the sender. If you have problematic staff, I refer to the sender. Hey, I would say HR, take back. But when you transfer to Mukono, tomorrow you'll be in where? In Mukono. So we can't transfer a problem. Yes, requiring lawyers to come to meet fixed cases. I plead guilty, and I'm not about to stop. I can only improve on it. Those are the indictments. Generally, delayed judgments and notices. Personally, I don't have the terminology of judgment or ruling on notice. I don't have it. Sincerely, if I've given it to any of you, you better put up your hand and we revisit. Judgment, ruling on notice, out. If I can't rate your ruling today, I will tell you I'll rate it tomorrow. If I find it very complex, I will tell you I'll rate it in December, this date. And that's it. So, notices are out. So members, we only need to appreciate that land division, like any other division, is clogged. Each and every litigant wants to have a day in court. But with the human resource we have, it is not possible to have all cases heard in a given calendar year. It is not possible. But the temptation we fall into is for us as judges to attempt to please each and every litigant by recording their witnesses. PW1 in case number 1, PW1 in case 1,000. At the end of the month output, 0. And then you tell PJ, for me I recorded PW1 in 1,000 cases. If I'm the principal judge, I just say, no work done. PW1 in 1,000 cases. So you are recording, you are leaving other witnesses to who? I appeal to colleagues that if you can't finish a case, do not start it. I'm not the principal judge to direct you. I'm advising that it's good practice. If you can't finish a case, do not, so that the principal judge can find another judge to do it. For me, I've told people, if you think I'm very conservative with my dates, report me to the Chief Justice. I will go and tell the Chief Justice, I have these 300, so the 900 is not my problem. My problem is these 300 in this calendar year, and I'm ready to deal with them. So if you think I'm not doing them, report me and remove me. So, colleagues, we need to bear with each other. And for the lawyers, there's no need really to hide in these things. This morning, because of my practice of summoning lawyers to come for dates, one of the cases we fixed inter partes with a lawyer matured this morning, and I was ready. The lawyer did not come. I told the litigants who are before me that you are lucky you are here. I cannot dismiss your case. But otherwise, by now, it will be dismissed. Then I told them, if you hired this lawyer and is not doing good work, you better find another one. Because you have lost your day today, the possibility of you returning to my chambers for a hearing, this being a 2021 case, you are very lucky that it had its day today. Otherwise, if I did first in, first out, as I heard colleagues saying, a 2021 case in land division will never have a date today, a hearing today, because of the workload. So when we say in this contract it is a 2021 and you misuse the date, we say bye-bye, till next year. Let me deal with a 2017 and 2016 because of first in principle. And we agree. So I appeal to you members to bear with me. With my few innovations I brought, it's not for bad reasons. It is for good reasons and intentions. And I am going to take this indictment to the division and we shall consider it together as judges in the land division to try and attempt to answer, provide solutions to the problems which you have raised. I thank you so much for God and my country.
The learned Attorney General, my Lord PJ, professional colleagues on the bench and the bar, I am standing in for Dr. Basheja, who is the head of division at ICD, and he said his apologies because he's away on short leave. I'd also like to correct the record that Senior Counsel Moses Adrico said I was a judge at the Commercial Court. I am formerly of the Commercial Court, but now of the ICD only, although I did do some work at the Commercial Court. Justice Gidudu and my senior colleague, Justice Elubu, mentioned things about the ICD which are valid, and so, but I'll add to what they said. And also in the context of what Counsel Kabega raised about bail, bail in the context of prolonged incarceration, prolonged detention. The problem with the ICD, problem in the context of what Counsel Kabega raised of prolonged detention before bail, stems from the law that sets up the ICD. Basically, the ICD is a creature of the International Criminal Court Act, which is a domestication of the Rome Statute, which is fraught with very elaborate procedures, trial procedures. Like Justice Elubu said, by the time you start to go through committal to come to pre-trial, trial, outreach that he mentioned, somebody who has gone through the normal, municipal, the local criminal court or the national criminal court will have finished and even probably served their sentence. The rules of the ICD actually are a mirror of the rules of the ICC. And so the same protracted procedure is replicated in the rules. Now the rules, the problem of bail emanates from the provisions of the rules that only mandate the trial judge or the trial panel to grant bail. Now that means that bail cannot be granted anywhere along the way. That is what the rules provide. So obviously that causes problems, because by the time you go through pre-trial, it's a very long time, usually minimum of years 1 or 2 plus. So there is a problem in there. Now, about a month ago, we had a similar engagement like this one with the stakeholders, and that problem came up, and we came up with recommendations, and which is an opportune moment for the PJ and the Attorney General and others to take up. The proposal was that to mitigate the problem, that a two-pronged proposal, the structure of the anti-corruption court, where you have a lower court with the magistrate, is adopted. And in that way, you'll have, you probably have 1 or 2 magistrates dealing with the pre-trial process, so that will hasten the, the proceedings. That might call amendment of the law or the rules. The second one was that the requirement for the pre-trial, the entire pre-trial process, is revisited, because by the time you confirm the charges at the end of the pre-trial, actually when you read the decision of confirmation of charges, you have almost done the trial. It's like a judgment of the, you only have not examined the witnesses, or, but you probably just plug in, and that's the same judgment. So there's a school of thought that the pre-trial just serves to cause pain, but also perhaps elongate. But that should be if the court, the ICD, is to maintain its international character. The question should be, do those changes go to the DNA of an international crimes court? If they do, then, we might make the changes, but then take away the mandate to try international crimes. That, because the procedure will not be the standard that is expected of that kind of court. Those are the proposals that were made. But in the meantime, a local in-house solution has been created in a decision that was made by Justice Okalany sometime last year. In that decision, and which you can get from our court, that decision is basically, what it does is it renders Rule 54, which provides that only a trial judge or trial chamber can, grant bail. It basically, her argument is that that decision offends Article 139 of the Constitution, the Trial and Indictments Act, and the Judicature Act, that provide for bail to be granted by High Court, or at any stage of proceedings. So that decision holds. It removes the discordance between those provisions of the Constitution and the Judicature Act and the Trial and Indictments Act. And so it might heal the malady of having people incarcerated for a long time before granting bail. Now the thing is, for that to be carried either into changing the rules or even amending the act. So that is a provision, a decision that can be taken advantage of by the practitioners in the ICD. I thank you.
Thank you, my Lord. I would like to recognize the Administrator General who is with us this afternoon, Mr. Kasibayo. Thank you. The Honorable the Chief Registrar, perhaps you'll come and make a few very brief remarks. I'm very conscious that we have overrun our time. Thank you.
Thank you very much, the Honorable, the Attorney General. My Lord, the Honorable, the Principal Judge, please allow me to adopt the protocol and quickly provide general responses to some of the matters that were raised. I'll be responding to a couple of issues that came up in the general matrix that was read by Senior Counsel Adrico, and then a few of the matters that arose during these deliberations. Now, as a general comment, I just want to assure our beloved court users, the advocates, that there is a lot that is happening behind the scenes of the judiciary to try and improve how we operate and how we can improve access to justice. Now, regarding the first issue, which was about the few number of judicial officers, I'll be making a general comment that cuts across the entire judiciary. The good news is the Commission is finalizing appointments. And when all this happens, for the first time, we shall have 82 judges in the High Court. I think we have not had this before, and so it will certainly take us time to feel the impact of these additional numbers, because 11 should be appointed during this exercise that they are on. Number two, we expect to have all the full registrars that we are having in the structure. That is 12 of them. And then the deputies, we will be raising them up to 42, which is about half the number in the approved structure of 80. And quickly to respond to Justice Ketrima, the ratio that we have in the approved structure is 2:1. 2 judges being served by 1 registrar. That is our structure. The issue to be worked on now is the implementation through the recruitment. But otherwise, I think that can take us a long way when we have that in place. The other good news is that we shall be having, for the first time, 90 chief magistrates. So this is going to mean that some of the areas where we have chief magistrates circuiting and handling 2 and a maximum of 3 magisterial areas, they will have chief magistrates. At least the original 82 plus another 10 will be having chief magistrates. And I believe that issues of backlog in some of those categories will be highly addressed. And lastly on that, we shall also, for the first time again, have about 445 or more magistrates grade 1. This means we are going to continue expanding our coverage, and so at the bottom, I should say all should be getting much, much better. Now, regarding the second issue, inadequate staffing, now particularly about the non-judicial officers, just to give information, we had and presented a structure and establishment for approval of cabinet together with that of judicial officers. The one of judicial officers was approved. As I speak today, I received the good news that we have been scheduled to present that particular cabinet memo next week. So our prayer is that once the structure and establishment of the non-judicial officers is also approved, and then the recruitments go on, the complaints of clerks and inadequate secretaries who in the end affect record of proceedings and transcribers will be addressed. And I want to thank the Honorable Attorney General who promised to continue supporting us, because if you look at our strategic plan, our plan was to ensure that by the end of the plan, 2025-2026, we would have recruited in most of these positions. Corruption, yes, that one is a big elephant for all of us to fight. But what are we doing? We have finalized a domesticated anti-corruption strategy for the judiciary. We believe the same will be approved by the Judiciary Council this quarter, so that in the next financial year, we begin to implement. What are the highlights of it? It has 4 objectives. 1, we want to enhance our efforts in preventing corruption. And one of the key things here, we want to strengthen our supervision. so that, as they say, prevention is better than cure. If there are areas we can prevent, so much the better. Number 2, we want to effectively and efficiently detect and respond to acts of corruption. In that strategy, we want to have more of a hotline and a quick response committee that will quickly handle and address issues related to corruption. So we believe once implemented, we shall gain some miles in this fight. 3, which is most important, we want to promote and sustainably entrench a culture of excellence and integrity in the judiciary. And lastly, we want to promote good practices in induction and management of staff. You have raised matters about the quality of decisions, and I want to say, if we are talking about adequate induction for judicial officers, in the region we are still lagging behind. We were in Tanzania, and in Tanzania a magistrate takes 3 months to be groomed and prepared, because they have a fully fledged institute that is able to train them. Judges take about 3 weeks. For the first time this last financial year, we had 2 weeks of full-time residential induction. What am I saying? We are making strides, slowly but surely, as the funds permit, to ensure our officers are better. On this issue of disappearance of files, besides ICMIS, and our plan to ensure that we begin to digitalize all our records, we are also launching this quarter what we are calling the Registry Operations Manual. We are alive to the fact that most of our courts are still running a manual system, but we need to guide them on how we are going to standardize and manage our files from registration through the hearings and trials to archival. And we believe that this will address the issue of lost files, missing files, because we are creating clear responsibility centers with clear roles in that manual. So when it comes, we shall be again happy to relay it to you. Lastly, on this matrix, just a quick comment on ICMIS to give Mr. Mutavingwa some comfort. Let me just highlight 2 gains we have made. We have gained through increased registration. Secondly, we have also raised more revenue. I can assure you that there are days where people used to cut corners with court fees, but that has since improved. And you said, yes, we phase it. Indeed, we phased it. Initially, we had planned to go full blast to about 18 courts, but we downsized and started with only 7, and then added on Luwero High Court Circuit, because the circuit took on cases from divisions which were already on ICMIS, and so ICMIS had to follow the circuit so that the cases could pick up. And when we started with the 7, our plan was to roll out in the next month, but we did not, because of the challenges which you have raised and some which we are still addressing. But I want to tell you that recently we had a top management meeting on ICMIS. We have identified the issues, the technical teams are working, and surely we shall keep addressing the problems as they present. As you agree, it is something new, so we are all learning, but we are determined. And I wanted to propose that in the next forum, when we have this meeting, perhaps ICMIS can be given some 10 minutes to come and highlight certain things, the gains, the challenges, and the steps that are being taken to address them. I'll quickly run to the other issues that were raised. Councillor Kabega, thank you for what you raised about the need to have Supreme Court and Court of Appeal here. Mine is just to encourage you who were invited. Tomorrow, Supreme Court is having a court users meeting, and they have invited advocates. Mr. President, I hope you got your invitation. I think it would be good to raise the matters that you would like the Supreme Court to hear. So utilize some of those fora to raise these matters. The delays in issuing of PCs, I want to plead guilty on this as well, but to just say it is not intentional. What happened is we reduced on our staff because some of them got promoted. They became judicial officers. And the staffing gap has affected us as well, but we are doing whatever we can to improve. We hope that the next cycle will be much better than this one. And also, just to tell you something, there is a particular machine we have tried to look for, and it has been difficult, but we will not give up, all aimed at improving the efficiency in this process. So we regret those delays. And our manual system with over 7,000 advocates doesn't make it easy, but we are going to deal with it. Communication to advocates, I want to say members of the lower bench, the registrars, the magistrates are all under instruction. One, to have WhatsApp groups in their jurisdiction, and always ensure timely communication of absence. I think in the last meeting we said, where these issues persist, let us bring up the individuals to me, to the inspector of courts, so that we address them. Because sometimes there are people who are doing the good practice. But if there are those few who are not, bring them up and we handle them. Judgment writing styles, again, information. The judiciary is working on a judgment writing tool. Further discussion will be internal. When it's ready, you will certainly be notified. Mr. Mutabingwa, let me just say, let's all fight this corruption in the judiciary and in the justice system together. We try with the administrative sanctions, and I was telling some people earlier that so far since I became chief registrar, I have interdicted 7 judicial officers, 4 chief magistrates, and 3. Keep bringing these matters. But as a caution, administrative processes take time, and sometimes they get frustrated along the way. But isn't corruption a criminal offense? Why are we denying Justice Gidudu work? Let us arrest these people who have persisted. You know them, you know their ways, you know through their agents. Let us have people arrested. I remember when I was at anti-corruption, we prosecuted and convicted some judicial officers. It sent some warning signs. So let us not lament. The State House Anti-Corruption Unit is there. IGG is there. DPP is there. Let us send a clear message through all the platforms that we can use. Lastly on that, to improve the inspectorate, we are working on regulations. In those regulations, among other things, we are providing the soft tools of how to improve integrity in the judiciary. One will be through institutionalizing peer committees, that is one. 2, reviving the Judicial Integrity Committee that went round and carried out integrity surveys. That is coming back. But we are also simplifying the complaint process by providing a form in it. So Mr. Mutabingwa, the people up country can just quickly fill in that form, and it will avoid the process of writing too much because it will be shorter and clearer. Once these are gazetted, we shall again be able to come and share that those regulations. As I wind up, let me talk about bar bench. There was a proposal by Civil Division that we need to make this a best practice. Indeed, again, information, we are again, because of the administration of the Judiciary Act that allowed for regulations, regulations are underway for committees of the judiciary. And with those committees come subcommittees. One of those we've covered is bar bench, is the regional coordination committees to cover the circuits, the court users committees to cover the divisions, and the district coordination committees to cover the magisterial areas. So these are being institutionalized so that every division should have that platform to engage as we are, and we continue with that. Lastly, let me just give you a picture of how our statistics look like as we talk about work and backlog and what the judges can do and cannot do. As we ended the month of March, we have 165,124 cases. Of this, our backlog is at 46,152. So this accounts for about 27%. But I must say this is an improvement. If you compare 2021 now and 2020, we were at about 33%. What am I saying? We are moving, perhaps not at the pace we want, but there is some progress that is being registered. How is the High Court looking? High Court alone has, the divisions have 29,298. Of this, 9,630 is backlog. The circuits have the highest, 38,469 cases. Their backlog is at 18,967. If you added all this, you'll find the High Court has the highest with 67,767. The good news, we have 20 circuits, up from 14. I think they have only been there for close to 8 months. I think when we evaluate their performance 2 years from now with the new judges that will be recruited, I believe we will see a big difference. I conclude by concurring with one of the earlier speakers that the success of this forum will surely be in the implementation of the resolutions. Thank you very much. The Honorable Attorney General and my Lord the PJ have been added another assignment here to invite you, my Lord the PJ, to come and make closing remarks, and then you invite the Attorney General to wrap up and close. Thank you.
Colleagues, I was a lecturer, and I know the concentration levels of students. Because, I mean, let me not go into that. But so I'm not going to bore you a lot with the remarks. I can only say that these engagements are healthy. It is very good for someone to come and tell you that you are naked, and then you find a way of covering the subject. So I thank you very much for telling us that we are naked. And that is the purpose of these meetings. Yeah, so, and we have also told you where you are naked. And this is a two-way process. And I encourage you, colleagues, that we are not any better than the advocates who sit on the other side. It's only that we sit on different sides of the divide. We all have one objective to achieve. Yeah, of course, many of the responses I wanted to make, I think the Chief Registrar has summarized them. So, apart from maybe you proposed that you form the committees, I think that was Councillor Kabega, you proposed that you have formed the committees to interact with the divisions, and I suggest that those interactions should be quarterly, because I also have quarterly meetings with the judges. And the meetings should happen before my meeting. So then your concerns can feed into my meeting, which I have with the heads of divisions and their deputies, as well as circuit judges. And I can promise that all these issues you have raised, we are going to dissect them in our meeting, which is coming up this month, which we hold quarterly. The heads are here, but the heads of circuits are not here. But we shall also bring them to speed about the concerns which you have raised. I think with those few remarks, I had so many things to respond to, but I think in the interest of time, I'm not going to do so. Since we have identified them, we shall put them in a matrix and then assess ourselves periodically how far we have gone. Where we have not achieved, we should condemn ourselves. Where we have achieved, we shall say, this is how far we have gone. Thank you so much. With those few remarks, let me invite the Honorable Attorney General to make concluding remarks.
Thank you very much, Honorable PJ. PJ says he was a lecturer, so he understood the levels of concentration. Now, for me, I'm a politician. We don't understand the levels of concentration. give us a mic, we speak. Whether it's at night, during the day, you've been there the whole year, we don't really care. But really, everyone who is here and who has stayed online, thank you very much for taking off time off your busy schedules to attend this. The solution to any problem starts with talking about it to identify that problem. We have done that today. The challenge that you have set for yourself, President ULS, is that you have given us a matrix. That is a winner. So we have something we can go and measure against when you bring us the matrix next year. So next time we meet, we need to be able to track. So tracking this resolution is very important. And the accountability of all stakeholders in the justice system is important. The truth shall set you free. Like the PG has said, if it is true, tell him he's naked. And you move on. Now, for judicial officers, the issue of corruption, we've talked about it, we've rendered an opinion, no one is going to arrest a judicial officer. At least I've rendered that opinion. If you have a complaint against a judicial officer, we have a clearly set procedure that you must follow. Why did the law do that? The law was mindful that this person, when he finishes delivering a judgment, there is a person who is happy and a person who is unhappy. So they said, go to the Judicial Service Commission, who are also set with skills that can actually discern whether there was actually something wrong or right before you can go to Justice Gidudu as a criminal. So we need to be very careful. So I don't want anyone to start saying they are corrupt. And the lawyers who have spoken to me, I know I've told you, they are corrupt. I don't know them. I don't agree with that. You tell me he is corrupt, and this is the evidence. If you don't have that, we stop talking about it. So lawyers here to stand here and say they are corrupt without telling us who is corrupt and the evidence of their corruption, stop it. You have to be bold. If you think you really have a fight to make and you really want to contribute to the development of your country and this judicial, you must be bold. Other people died for their countries. For you, all you're going to do is talk. Talk. So let's follow this process, and the Judicial Service Commission, when we get these issues, we address them. And we are bold enough to say, no, you are wrong, and this is what is going to be done. So we'll deal with them. ECMIS has been addressed. Succession Act, the Administrator General is here, he has heard, and I expect that action will be taken to make sure that these rules are put in place so we don't have these challenges. But the DPP is not here, and I just need to probably make a comment in as far as what Justice Selubu was raising in issue of the DPP. The resource envelope of the government is limited. Actually, when I was on the other side, I used to say, why don't you do this? Now that I'm on this side, I'm very careful now about resources. I think I'm going to become a big miser by the time I'm done with this. Resources are limited. So the question we had to grapple with at the time was, do we start with the judiciary, or do we start with the DPP, or do we start with the Attorney General's chambers? It was a very big debate. And at that point, we felt that certain things can be done by the judiciary even without a prosecutor. For example, if a person appears before you having been on remand for a constitutional period, without a prosecutor, the judge can grant the bail. So the decision had to be made. Whom do we deal with first? So the decision was made to say, let's first equip the judiciary, because once they are there are certain things they can do on their own which can help in the ends of justice. And we're looking at criminal justice really. That a person is on bail 120 days, appears before a magistrate. I don't need a prosecutor if I'm a judicial officer. I count the days, I say, the Constitution says this is what happened. So whether there's a prosecutor, so that decision was made. And I'm happy that we are moving. We hope that by the end of this year, we would have hit the 100 number of judges. Now, we are then moving now, one of the things the Chief Registrar was talking about is we are going to amend the Judicature Act, because the Judicature Act gave a ceiling on the judges of the Court of Appeal and the Supreme Court. While the Cabinet has agreed to up that, you need now to move the process of amendment in order to do that. The government processes are that, but we are working on it. So, but what has happened now is that the DPP's officers have been enhanced. Their salaries have been enhanced. Right now we are moving to remove the tax on their pay. So we are saying, let the few 300 who are there first be comfortable, other than, like the president would say, to have democratic unhappiness. You can have 1,000 people who are democratically unhappy, or you can have 300 who are happy and delivering. So we shall now hold the 300 who are happy to account for what they have done. So that's where we are, but something is being done, and we know it has not hit a critical stage. We now have motivated DPP prosecutors who should be able, who are currently 382. We know we have so many, we have 100 judges. So even if 100 judges were sitting to handle criminal matters, we have enough prosecutors to be in that courtroom. And we have another 100 chief magistrates. So we have enough prosecutors to be there. Now we shall then build on from that. So that is where we are. The Jealous House has commenced. Unfortunately, the tower with the divisions hasn't started. We started with the tower for the Ministry of Justice. Because I was grappling with a very difficult decision at the time. I didn't even have a Minister of Justice. And I said, which tower should we start with? In my wisdom at the time, I felt our tower was very important. So we started with that one. The recruitment of judges has been addressed, and I'm just addressing the issues which are from the executive side. But there's something that Councillor Karungi raised, which continuous training of judges. The judges can continuously train, but are we lawyers continuously training? What is the job of the lawyer in the courtroom? To do the work for the judge. So you tell us you gave the judge the judgment, which was most recent, and the judge didn't rely on it. So this system needs each other. So if the judge has 6,000 cases, and you know you have one case, or 10 cases, spend so much time researching on your case. Give the judge all the material you need for your case, so the judge does not have to go running out of the courtroom to look for the authorities. If we support each other that way, we will stop pointing and saying, the judge didn't see this case. Just say, I gave you the case, and you refused to read it. And I distinguished it for you. I even highlighted it for you. We do that in the Court of Appeal. It's not been a good practice in the High Court. I don't know why. If we can pick that same practice and bring it to the High Court, it will make the judges' lives easier. Photocopy the authorities, highlight them, mark the pages, point the judge to where. It's your case, it's your client's case. Point the judge to where you want them to read. And once you do that, then we can blame the judge, because the record will be there. But if the judge doesn't know the case, I don't think I can blame a judge, because I don't think we know all the cases. We are not capable of knowing all the cases. So we need to be prompted all the time. So while we ask the judges to develop, we must develop, and we must up our game. And when the judges tell you they are too busy, the neater the job you do, the better for justice, and the quicker the justice. Chief Registrar, we have to address an issue which is fundamental, the issue of the PC. I actually didn't know. It is not enough to say we are sorry, because we have a legal issue. So we need to address that legal issue. What happens to an advocate who has done their work, filed their documents, but because of a failing on our part, we are unable to provide them with a PC. And we had this when we had a problem in government a while ago where they couldn't issue driver's licenses. I remember the Ministry of Works then issued an instruction that just move with your receipt to show that you have paid and you have met all your requirements, and it's only my fault. So we need to address that very seriously, so we don't get, because me, I can see a lawyer suing me, and I need to avoid that suit. So people in Ministry of Justice, we need to get back and address this before the end of the week. Because if it is our fault, the person who is not at fault must be allowed. So we must find a provision in the law which allows us to allow them to work because it's not their fault. The retirement of judges, we have discussed this many times, and I agree. At 60, at 65, the judges are still, but it's the law, it's the constitution. The last time we did this survey, you know, when the law meets politics, there's a danger. The demographic you're talking about in Uganda here, you have more people below 20 than the ones above 50. So if we go to vote and we ask whether we should allow people to stay, these people of 20 may vote us out of office. And we still want to hang around for a little longer. So, but it is an issue that we really need to address. And Justice Kaitirima also raised it, the issue of retention of judges. And it is something that we can look at. But again, it comes to the resource. If I retain this judge for 2 years, I must pay them. Wouldn't I be better off recruiting a new judge who will give me more years? It's a balance that we, but it is something that I have noted and we are going to look at. Succession Act I've addressed. ICD. This issue, we are grappling with it. It's a real problem. We are state parties to the Rome Statute. It's a treaty position. The treaty position gave us the ICC rules in order for us to comply with that status. We are not at real liberty to just change it. But we may decide as a country, and this is a conversation we can say, well, this Rome Statute thing is not working for us because it's not, and then we have to remove ourselves from. Some of these treaties, you can't, the treaty, the Rome Statute does not have a provision for reservation. You're either in or out. You can't reserve certain things and say, I will be in, but I will not accept this process. No, no, no. You're either in or you're out. But it is a conversation we should continue having, and we shall make sure that we look at it, because it's a bit problematic. Without saying much, I was going to say I hold some views as a lawyer, which I cannot say here as an attorney general because it may attract a suit for me. But there's something that we need to deal with. Justice Kaitirima raised the issue of family division judgments. Judgments of the High Court are not confidential. Judgments of the High Court are not confidential. If a man and a woman decide to get married, and what they do in their home is confidential, the moment they subject themselves to the public, and I think because you've guided them, that if you want to keep your affairs private, do it through mediation. If they refuse and you write a judgment, it is public. So lawyers, you are here. You need to choose with your clients and decide, do I want to make my clients' bedroom affairs public, or do I want to keep them private in mediation? And then the learned judge has told you, the honorable judge has told you, do it through mediation. But my lord, if they decide not to do it through mediation, publish. It's public. Because you have guided. They have decided not to take your guidance. Publish. But they cannot be thing. In the industrial court, we hear you about resources, but I just want to give you something. In the 24 states attorneys, every week we receive an average of 474 contracts to review. Every week, at least 474 contracts to review. Now you can imagine a procurement contract, and you are supposed to review the process from beginning to end, and those are the majority. Now we haven't talked about the MOUs, we haven't talked about the court cases, we haven't talked about, but there are 174. In fact, my state attorneys are going to think that I don't like them, because I sat there and they said the DPP should be increased, the DPP should do this, and I was looking on, because there is a plan. There is a plan. We cannot get away from that plan. If we jump out of that plan, we will never get to where we are going. So the two that you have must account for the work that they need to do. Fortunately for you, the High Court has unlimited jurisdiction. So we are dealing with that unlimited jurisdiction first to make it able to meet all our needs across, and then we can go to the specifics. So I cannot promise you that we are going to deviate from that plan at this point until we have the 151 High Court judges, until we have the circuits of the Supreme Court and the Court of Appeal set up. The other players in the judicial sector will have to grow slowly to get to where we are going. Because we know that right now the amount of money that is tied up in our judicial system is so much that if we don't unclog it, we may actually shank the economy. So we hear you, we understand the challenge, but we have to address it. So, honorable colleagues and honorable members, judges, I request that you consider one thing. It may be better for us lawyers to know how long a case will take me than not to know at all. You're better off telling me from the day you file to get out of this courtroom will take you 3 years than for me not to know at all. It is something that the judiciary needs to think about and say, when I enter the judicial system, I'm going to get out in 3 years. We manage our clients better because when we are talking to the client, we say, no, in the judicial system in Uganda, when you go to court, it takes 3 years. And if you say it takes 3 years, let it be 3 years because we have 100 judges. If it becomes 200 judges, it will take us 1 year. If it takes us, it will take us this many years. We need to know that. We need to have some predictability on when a matter shall end in court. Because for us, we want to do it as business. Say, okay, it's going to take me 3 years. I sit with my client and say, 3 years, the interest is going to be 100 million. We are looking for 200 million. This person is offering 50 million. Do I go with this? But if it becomes 10 years, the conversation is different. I just tell my client, the court told us we are going to take 10 years, just pay and we go. So give us some indication of what time it takes to turn around a matter. I can tell you today, it takes us in our office 2 weeks to turn around a matter. We tell you 2 weeks from the date you send a matter to our office, the answer should come. And if it is after 2 weeks, you have the right to complain. And we try. It's a hard one. And if we are not going to do it in 2 weeks, I expect them to write to the client and say, your documents are not ready. We don't have this thing. It will. So when we fall out of the 2 weeks and we hit 3 weeks, it's bad. But once it hits a month, now, anyone who has a matter in the Attorney General's chambers for a month, they are throwing a tantrum. They are angry because that is what we have told them. And we try to keep with that client charter. So give us something. With those remarks, colleagues, President Uganda Law Society, you have one fundamental task: to keep this matrix as a live document. Where we progress, we need to highlight the progress. It's very important for us to know that we are progressing or not progressing. This bar bench forum will only become better when we hold on to what is good. Because if a judge has told you that it's 1 month and the judgments are coming out in 1 month, let's record it. That court, it's 1 month. So that if it becomes 2 months, last year I said, no, my lord. Your court was 1 month. What happened? Why did it become 2 months? But if you don't record the good, you will not know when the good is becoming bad. So thank you very much, ladies and gentlemen. And thank you very much. And the way you have stayed here, especially judges, we know how busy you are with what you've told us. We really, really appreciate the humility. We thank you very much. And we pledge to continue supporting you in what you do. And we will do our part as members of the bar. Thank you very much.
We are just going to ask Senior Counsel Ruth Sebatindera to pass a vote of thanks on behalf of the Uganda Law Society, to the Attorney General, to the Principal Judge, to the heads of divisions, and to the Chief Registrar. And lastly, to our members, our bosses. As she comes, let me also recognize the council. Please, council, stand up. I forgot to recognize the council. The Executive Council of the Uganda Law Society, stand up as she comes for recognition. Thank you so much.
Thank you, President. I have a very simple task to thank you all. Let me begin by thanking the Honorable Attorney General. Hey, who is the agent? Oh, okay. Yeah. Thank you for, staying with us, but also ending in such a good way. Mapping out where we should be going on many of these issues, and for your pledge of support both for the judiciary and as head of the bar. Thank you, the Honorable Principal Judge. Yeah. Thank you. Thank you, all the High Court judges, heads of divisions, and all those present, all the High Court judges present. Our Chief Registrar, thank you. In fact, I had intended to say one or two things about, the recruitment program that we are doing at the JSC, but she covered it so well, so I will not even go there. Thank you so much. The registrars and assistant registrars present, thank you for being here. Senior counsel present. JMM, if I don't thank you, will I be able to come back there? Yeah? You'll be saying, you didn't thank me. Eh? Special thanks to our moderator, Senior Counsel Moses Adrico. Yeah. All of you here present, members of the bar, thank you so much for staying. It shows you're staying with the mission. The mission is clear. Justice for all in the case of the judiciary. And we are on the same mission. We are on the same side. I think strategic objective of the ULS 1 or 2 or 3 talks about access to justice. So it's the same. We are on the same team. So thank you for staying with the mission. The thing is to implement as the Honorable Attorney General has guided. Oh, thank you to all our members online, 750 members online. Thank you so much. Yeah, so with that, I'm asked to invite the Honorable Attorney General and Principal Judge and the heads of the divisions for a group photograph. Thank you and good night. Oh, I have committed a serious blunder. Thank you to the Uganda Law Society. President, can you imagine? How do I not thank my own president? Thank you so much, Uganda Law Society, Council, Secretariat. I know the drill behind the scenes. CEO, Moses, thank you so much with the team. Thank you. Good night.